May I please, Lordship?
Yes, please.
My Lord, this writ appeal may kindly be listed on 4th.
Which
Yeah,
writ appeal?
I have been pleaded as respondent number 1.
Hmm.
The judgment of the learned single judge is in my favor.
Hmm.
I have suffered a bank fraud, and there is a direction on the SBI to refund the money,
Yes.
against which SBI has filed an appeal.
Mhm.
And your Lordship has specifically directed that your Lordship would like to hear the RBI, banking ombudsman. And
Okay.
notice has been served on the banking ombudsman.
When
There
when is the
order-
next when is the next date fixed?
Lordship,
When is the next date fixed by the office?
next date has not been fixed, therefore I am making this mention.
Find out. Find out. Okay. If it is
Notice
so,
has
then
been served on the respondent RBI, and they have appeared through a lawyer.
we'll find out. Just we'll let you know in a while.
Meet with your Lordship.
Mhm.
I have got the item, my lord, that was for many times it was in the hearing list. It could not be reached. Now also, my lord, for 3 months it is on hearing list. The petitioner got.
Move an
from this
application
court.
for early listing. We'll direct.
It is in the list, my lord. I praying your lordship
Which
that it
list?
can be listed in the part 1, my lord.
Will you just give the
Hearing
slip?
list.
We'll see.
So many.
List,
Yes,
ladies.
my lord.
Take the slip, Mr. Charlie.
Or
We'll see.
May please, Lordship. Lordship, I beg to mention item number 49, ma'am.
Mhm.
And in this case, senior advocate, my lord, depositor will appear, my lord. He is
Hmm.
grievance, my lord. May I pray this matter may be taken up?
All right. Senior counsel, Mr. D. Saikia, would represents the appellants in these appeals. He is in bereavement, thus list
After 2 weeks, my lord.
on 7th November as played.
Yeah, please, your lordship. I beg to mention item number 62.
Yes,
We have taken consent from the other side. Lordship, this matter may be come up after vacation. Who's a vacation?
list of 4 weeks as played by council.
Lord, may I please, your Lordship, may I beg to item number 66 to 69, Lordship.
Yes,
My lord, that Advocate General, Sir Jabul Shekhar is appearing, my lord. He is on bereavement, my lord.
it is stated that Advocate General, Learned Advocate General, Mr. Saikia, would be appearing on behalf of the state in this bunch of matters. He is in bereavement, thus, re-notify on
After 2 weeks.
21st November as played.
Oblige, your Lordship.
May I, your Lordship?
Hmm.
Lordship, I beg to mention item number 64, Lordship.
Yes,
In this case, Lordship, I have yesterday, Lordship, filed additional affidavit. as per the last
we'll
case.
call it, don't worry.
Lordship,
call the
matter may be,
No, we are not adjourning it. He is not qualified. Why unnecessary? She is not qualified as to act as a HM.
Lordship, she is qualified, Lordship. The.
We'll call the affidavit, don't
Oh,
worry.
oh, oh.
Yes,
My please, your Lordship, may beg to mention 57, my lord, some accommodation may be get. Your Lordship has instructed me to procure some decision, my lord.
we have got the decision, don't worry. We'll let you know. Date of birth. We'll
Yes,
give you
Yes,
good number of judgments of Supreme Court.
yes, yes.
Daily list for orders, item 51.
Steps not taken.
My lord.
State of Mizoram. You represent Mr. Nair, who represent?
My lord, some of the private respondents, my lord.
All right.
There was a Lavazima orders, my lord. Sir, condonation.
51.
No condon, item 51. Steps to analyze. Condonation.
Service upon 42, 47, 57, 71.
Completed.
No,
Not completed.
not done.
Then I think it's.
Then Advocate General Mr. Das appears on behalf of the state. The instant interlocutory application is pending since the year 2018 till date, service has not been effected on respondents numbers 42, 47, 57, 71, 73, 74 and 94. Advocate General submits that service upon such respondents may be permitted to be effected by publication in publication.
Yes.
By way of publication, requisite application with this prayer be moved within 3 weeks.
Yeah.
Move an application order 20 rule 5 CPC 5 rule 20 We moved with him. 3 weeks.
Deeply obliged.
Item number 52 to 54.
Where is the council? Is the APSC selection matter to the FSL? Who is there for the APSC? Password. Let the council come.
Item number 55.
What's happening? Why councils are not appearing? 55. Mr. Barua. Respond number 8. Who is responding? Yes, you present?
I am appearing on behalf of Mr. Dinath.
Yes,
2 weeks time will be granted for filing affidavit, my lord.
you want further time?
Yes, my lord, for filing affidavit. my lord.
Request is made on behalf of Mr. Dinath, Senior Government Advocate, Assam, to grant further opportunity of 4 weeks to file affidavit on behalf of respondent number 8.
Obliged, my lord.
Last opportunity is being granted for this purpose and no further time shall be allowed. Re-notify
Obliged.
on 20th November.
Item number 56.
Service has been effected on all respondents. Let the matter be listed for admission after 1 week. As per the office report, service has been listed after 1 week for admission.
Item number 57.
My lord,
Yes,
here only I can say that this petitioner, he has no knowledge about this because
ignorance of law can't be an excuse, gentlemen.
he has,
It's no defense.
yes, madam, he has given the correct documents and correctly it is because
It's immaterial, gentlemen. He had to file a suit for declaration,
yes, ma'am.
dismissed, IA as well as the writ appeal.
Yeah. So liberty may be granted to
There is always liberty. Who stops you?
limitation.
Who stops? Limitation, you move an application. Why should we condone? You're climbing the wrong tree.
Less.
Item number 58.
Lordship, in this, my senior is in a whole case, Lordship, in another court.
And you have to decide your priorities. This is happening right, left and center.
Lordship,
Every day.
I'm very apology, Lordship.
What is it, Ms. Tiwari?
Yeah, my lord. My lord,
Udina Tiwari साहब ने क्या दिया?
my instruction is after 2006, after digitization, it is all system generated. So this is the letter allotting the code. This is ordinarily called certificate.
Oh,
It is generated by the system.
hmm.
And my lord, so far as NHPC is concerned, I have verified the facts. I asked them as to how did they verify it.
Hmm.
They told me that once challan was issued and they produced the challan showing the name of Brahmaputra Infrastructure, the number in the challan given,
Hmm.
they went to the portal of the Government of India with that number.
Hmm.
And in the portal, all the particulars of
Were there.
Brahmaputra Infrastructure were there. The copy of the portal, my lord, the hard copy, I have annexed along with the affidavit. In
Possible.
the affidavit, it is there.
Possible.
Much obliged, Lordship.
Item number 59.
Wait, please, Your Lord. My lord, in this case, my lord, the petitioner before your lordship has completed the work in
Yes.
January 2023.
Hmm.
And I have written to the department that I have completed it, kindly issue a completion certificate, my lord.
Yes.
My lord, the general condition of the contract mandates that within 7 days from the date when the contractor issues a request for issuing a completion certificate, the department is to intimate about the incomplete
Come
works
to page number 4 of the judgment. Para 5, page number 4. Read that and continue from there.
page number 4 of.
Para 5, you start from para 5, page 3.
96. Par contra, the learned CGC has produced a bunch of communication to demonstrate that the contract was entered on such and such, 11/3/2016.
What was the tenure of the work? Please let us know.
My lord, although the.
Simple question, sir.
My
First
lord,
answer.
1 year.
Okay, now carry on.
Now, my lord, though.
First, read the paragraph, then we'll
My lord.
hear you.
Par contra, the learned CGC has produced a bunch of communication to demonstrate that the contract was entered on 11/3/2016 and the date of completion was 10/3/2017. But even after an inordinate delay, the work was not completed by the petitioner. It was submitted that on 29/11/2022, as the work was lying standstill at 93%, the petitioner was served with a final notice to resume the work within 12/12/2022. And on default, the chief engineer respondent number 3 proposed to cancel the work at the risk and cost of the petitioner. By the letter dated 27/12/2022, the petitioner was put to notice to complete the work by 31/1/2023. Failing which the work would be cancelled on 31/1/2023. Thereafter, white letter dated 27/1/2023, the petitioner was put to notice to rectify the defects and to complete the balance work. By letter dated 23/2/2023, the petitioner was asked to respond to 8 queries relating to the work. Thereafter, white letter dated 10/3/2023, a list of defects were pointed out to the petitioner with a request to complete the balance work. Thereafter, white letter dated 9/5/2023, the work was cancelled and the petitioner was put to notice that the balance work would be completed at the risk and cost of the petitioner, followed by convening order dated such and such. By the letter dated 21/6/2023, the petitioner was put to notice that certain works, my lord.
Yes.
I'll just keep the name of the works, my lord.
Moreover, the petitioner was informed about the
Moreover,
assembly.
the petitioner was informed about the assembly and accordingly he was asked to attend the site on 28/6/2023 at 11 hours, which was rescheduled to 8/7/2023 and then to 26th and 27 July 2023 at 11 hours. And he was forewarned that on failure to attend, the BOO would proceed ex parte. Therefore, it is seen that the petitioner has had been put to 2 months notice on 29/11/2022 and again he was put to notice dated 27/12/2022 to complete the work by such and such. Failing which, the petitioner was informed that the contract work could be cancelled on 31/1/2023. In the considered opinion of the, should I proceed, Mal?
Yes,
Yes.
para 8.
Para 8. Moreover, it is noted that white representation dated 19/6/2023, the petitioner has invoked arbitration clause and had prayed before the engineer in chief for appointing an arbitrator.
What is the scope of interference in writ jurisdiction once you invoke the arbitration clause, sir? Let us know the law on that, please.
My lord, I have a judgment which says notwithstanding the arbitration clause.
Not only regarding the arbitration clause being a part of the contract,
My lord.
fact regarding arbitration clause having been invoked. Thereafter, what is the scope of interference?
Now, my lord, on that, my lord, I had a submission on fact, my lord. On the fact, my lord, because after this letter, my lord, we received a letter after the judgment was rendered, my lord, where the department has denied that they cannot initiate the arbitration.
You have other remedies for that.
Section 11 is there.
Yes, so that's the remedy.
Now, my lord, what I am, my lord, since my lord, admittedly 99% of the work is complete.
We don't know. We
The-
don't know.
My lord, they are saying.
These are findings of facts in para number 6, para number 5, which you read.
My lord,
These things are incomplete.
my lord,
Why the writ court is supposed to go into that?
absolutely. My lord, my humble submission would be this, my lord, that since admittedly 99% of the work is complete.
Nobody's admission.
Yes, my lord, it is there. My lord will kindly come to page number 75.
Yes.
Para 3,
Yes.
the second line. This is their letter, my lord.
Work was completed after how many years of initiation of the contract?
My lord, but then, my lord, this, there was extension on grounds, my lord, I'm not going into that because there were valid extensions, my lord. At no point of time, any liquidated
You were put
damage.
to notice in 22. Thereafter, despite that, they kept on giving you leeway, complete it, complete it, complete it. There has to be a stop to these things at some point of time. If you take your opinion, maybe even your arbitration proceedings may be prejudiced. That's your choice now. These findings are already there.
My lord, whatever order calls from your lordship, my lord, my lord, since they have come up with 4 different list of incomplete works, let them specify one list, my lord, give me 15 days time, I'll complete it, my lord. It will be in public interest also because fast tendering process will.
Don't bother. They will take care of the things. They have tolerated you for good 7 years.
My lord, those extensions were not attributable to me, my lord. That may
We
be
are not going into that. That's why we are not making any comment on that. But the fact remains that the infrastructure project of army has not been completed for 7 years, even though the contract period was of 1 year only. So you could have invoked the arbitration much earlier.
Then, my lord, in view of the arbitration clause, my lord, your lordship may.
In view of the fact that after addressing the court for some time, then counsel, Mr. Your good name, please.
M. Biswas.
M. Biswas, representing the appellant, submits that as the contract contains an arbitration clause, the appellant would be better advised to invoke the said remedy by approaching the competent forum. With the said submission, he craves liberty of the court to withdraw or we should dismiss. Choice is there with you.
No, I withdraw, man.
Withdraw the instant writ appeal. Hence, the writ appeal is disposed of as withdrawn.
I'm deeply obliged.
Item number 60.
May I please, your lord?
Yes.
An appeal challenging the order of the appellate tribunal.
Addition has been made on the issue which was never a subject matter of reopening of the assessment.
But
3 judgments of different high courts
lordship
and concurrent findings of facts.
Lordship, section 147 explanation 3, the permission.
That has been explained by the 3 different high courts that it has to be the issue has to be the one which was the reason for reopening of the assessment. No substantial question of law. You want us to wait for Mr. KL?
Yes, sir.
1 week has played.
Obliged.
Item number 61.
What is the status of the selection?
It is status quo.
Status quo.
Stay order by this court.
Yes. Who is appearing for the respondents?
Yes, madam. I'm the applicant, my lord.
For the private respondent?
Yes, madam.
It's total sham. Only on the basis of interviews, selections made. Total sham. The learned single judge has gone on the aspect that the decision to conduct the selection by interviews was not challenged. It was there before the writ court. Writ court should have exercised jurisdiction. Suo motu. It's a fraud or plain and simple. What do you say?
My lord, learned English council, Mr. E. Ahmed, my lord, he is out of station, my lord.
You should have said so. This is 2018 matter, gentlemen.
Yes, madam.
Tomorrow.
Tomorrow, my lord.
Yes.
I'm deeply obliged.
List tomorrow.
Item number 63.
May I please, lordship?
Yes. So Mazumdar was supposed to place on record those payslips.
My lord, already I filed the affidavit in reply to their affidavit opposition, my lord. As per affidavit reply, my lord, they have, my lord, implemented, they have granted the rate pay of rupees 8,700 to all the teachers who are similarly situated like the petition.
I have information to provide, my lord. My lord, on 1/9/2023, a committee has been constituted comprising the officials of my lord education department and the finance department, including.
Why should we wait for the committee's decision?
Yes.
Yeah. Why should we wait? Yes. All right then.
No,
We'll
my-
decide right now.
No, lordship.
Come out with a decision in 3 days.
Lordship.
All right.
My lord.
Let them take a decision. Learn council.
My lord, in the meantime, my lord, I have been provided the copy of proposal submitted by the inspector of schools, wherein they have, my lord, proposed for granting my benefit, my lord. That I may be allowed to place.
All right, then what remains?
Thank you.
Then Council Mr. Purkas, representing the petitioner, has placed on record copy of a communication dated 15 June 2023 issued by the Inspector of Schools CDC Silchar to the Director of Secondary Education Assam, as per which, the prayer of the petitioner appellant for grant of enhanced grade pay has been considered valid, and a proposal to this effect has been forwarded to the department. Then council appearing for the respondent submits that a committee has already been constituted by the department to remove this anomaly, and that the committee shall give its report within next 7 days. Re-notify on 4th October.
Item number 65.
$64, what happened? 64 is there.
Apologies. Item number 64.
It has not come. All right, let's wait for the affidavit. Let the affidavit come. Pass over.
Item number 65.
Also please the NRL matter lordship regarding appointment lordship.
Yeah, last date, Mr. Nair had given you that.
Lordship, that cannot be allowed lordship.
No,
That violates.
Ms. Bhagwati submits that the resolution dated 28/8/23 is not compliant of the statutory provisions and is not acceptable to the petitioners. Ms. Nair representing the respondent is not available. List on. Let it come back on in November then. 8th November.
March already.
లేదు.
Supplementary list, item number 71.
My lord,
Hmm.
I am the purchaser of CCM sand. And it is my fundamental right to place the order to the seller of the sand to deliver it adjacent to my house. And there is no banner and symbol for the 407 track was displayed in this lane after obtaining the order of the magistrate, which is required as per provision section 133 CRPC. And accordingly, seller of the sand got the sand, and whenever the sand was the truck was entered in this lane, and the respondent resting the truck and call upon the police, and thereafter I told that it's wrongful resting under section.
Why it has been listed here?
IPC.
It's a criminal writ petition basically. Arises from a criminal writ petition. What is a writ petition? What is the file? Writ appeal. It's the order of the learned single judge. Criminal writ petition, why appeals will come here? Nomenclature only writ appeal. All right. Yes. How does the writ appeal lie in a criminal writ petition? Does it lie? Is it maintainable? Can't be.
No, I filed a review petition, my lord, and it is sanitary.
The registry is, wait a minute, we feel that your appeal is not maintainable. The registry is directed to make a report regarding maintainability of this appeal. List on when can you come back? We'll need a report. In our opinion, your writ appeal is not maintainable. It arises from the order passed by the single bench on the criminal side, criminal jurisdiction. So writ appeal would not be.
Order, my lord. It is part of the.
When can you come back, Mr. Singh?
Second petition is not maintainable. For
When,
this reason, I appear before the court.
When can you come back? We are asking you.
Next.
We are listing it again. When can you come back?
আপুনি criminal appeal কৰিব লাগিব।
Eh?
Appeal ত নহ'ব। Next step টো দিয়ে। Next step কেতিয়া আহিব পাৰিব আপুনি?
Next day is, my lord, again I shall have to come.
Yes, you can address by VC also. Tell us the date.
October, first week of October, my lord. That
Yes,
is,
all right.
Fourth witness day.
Yes, 4th. List on 4th. Eh? Which one? Pardon call for you. हो गया. Later.
Daily list, item number 1 to 47. Pardon.
Sir, my lord, before my learned friend starts, I think last time your lordship has said there were certain arguments to be advanced by some of that last date.
Yes,
Large
yes.
chance is given. That's what I have.
Anyone
seen.
is there?
My
Anyone?
lord, three particular candidates. I don't know, my juniors also is not there. Some ACS, my lord, 3 is very limited. Already we argued.
You'll be
What-
addressing.
Yeah, yes,
Alright.
addressing. That
Please
regarding
proceed.
only the point of regarding their ACS, and that is invocation was under 20C. Your lordship, not just I will tell because your lordship has heard. It is under 20C, it has been invoked. But the invocation was not under 20E, which was perimeter to other rules under 19(2) of the Assam Taxation Service Rule. And so far as the another transport is 16(2) is perimeter. Only on 20C they have invoked. So if your lordship kindly see 20C, it is regarding about integrity, it is antecedent, moral. That's what whether that amount to my lord stigmatic or not. That's what
That argument Mr. Chaudhary raised
Yes,
on the
that's-
first date. sir.
That's what I will, I just want to place it before lordship. If it is a stigmatic, because now future employment, they will come and they say that no, so where is the question of employment? It is not 20C, integrity is concerned, to antecedent. So this, my lord, is exactly is a stigmatic order. They have invoked the rule so far as 20C is concerned, my lord. And I don't know, my lord, there are two documents. I am feeling very embarrassing to point out, but I was not before the learned singer. So APSC, that one question has been put before your lordship. That if you see APS, 2017 is what we said, that is their services is, they have completed. Your lordship just recollect 2017. There was general transfer order. Thereafter, your lordship recollect that we have shown
Completion of probation period.
yes, and a notification issued. 2 letters thereafter we have shown before this court. One is handing over charge a provision, and next letter is taking over a charge, which is the word provision. But they came up with a notification on 20th of January 2018, where lordship has said that whether it is a gazette or not.
That
Yes,
let Mr. Kohli
Number
respond.
2, we said last occasion lordship gave a scope. We said we made an RTI. In the RTI, we have come to know that already we applied, and they said this type of notification has not been.
Let him respond on that.
Now the question what I am taking leave is that your lordship has asked 2017 draft transfer in between to what is the interim, what is your status? Now there are 2 documents, my lord. I don't know whether you let him argue 2 documents, which was not.
Where are
Yes,
the documents?
I'll show it, my lord, because my junior who is here, we always, nowadays, my lord, we have to come first.
You don't have any shoulders to bank upon.
Yes. 2 documents, I will show it, my lord, before your lordship. During the
Whenever,
course, because
all right,
time
let,
is-
let Mr. Kohli start,
Yes.
then we'll give you the opportunity.
Yes. I am
Yes.
deeply obliged, my lord. Please, my lord.
Yes, you are addressing the court. All right,
Yes, my lord.
good. In
Item number
which rate of
34, my lord. Writ bill 185 of 2021, my lord.
appeal number?
185 of 2021, item number 34.
181 oblique,
185, my lord,
185 oblique.
2021.
Yes.
My
What's
lord,
your
I
name?
adopt the arguments of the Learned Senior Counsel Didas, Learned Senior Counsel DK Mishra, and the Learned Senior Counsel Ken Chodri, my lord.
Okay. Adopted the Mr. So and so adopts the arguments advanced by Senior Counsel, Mr. DK Mishra. Mr. Das.
Item number 24.
Hmm.
I'm adopting the arguments led by senior counsel.
Note Kalyan, Mr. Khan. Yes,
24.
okay,
I'll trouble your lordship for 2 minutes, man.
yes.
Otherwise, man, most of the submissions have been taken
Which
care of.
item number?
I'm in item 16.
Then yes,
This pertains to transport department. My very short submission, in fact, all those judgments have, I'm instructed that most of these judgments have already been placed. If your lordship will just allow me to place the order, impugned order for a moment, my lord, if your lordship will kindly have item 16 for a moment.
this SB judgment, single bench judgment.
No, my lord, the
No.
order by which my services have been terminated.
My lord, with your lordship permission, my lord, just I'll take a leave, my lord.
Sure. Yes. If your lordship kindly turns to page 82.
Just,
This is writ appeal number 141 of 2020.
yes. Page 82.
Page 82 is the order by which my services have been terminated. And
Yes.
right at the bottom of that page, your lordship will find that they have invoked sub-rules 1 and 2 of Rule 19
Yes.
of the Assam Transport Service Rules 2003.
Yes, please.
But my respectful submission is Rule 19 envisages a period during probation. And they have, for the purpose of termination, they have gone to a date prior to my appointment itself. So in a sense, my lord, if your lordship lifts the way,
Prior to your appointment.
because they have taken note of purported illegalities committed during the process
Yeah,
of
of course, that is there. That is there. Yes.
So my respectful submission is
This talks of conduct in service.
during service.
During.
So
service.
therefore, if your lordship lifts the way, your lordship finds that in a sense, these rules are not even applicable. What has in fact been done is the government has exercised powers under 162. And for that purpose, my lord, these judgments, I won't trouble your lordships, perhaps these judgments have already been placed. There are two judgments in particular, my lord. Inderjit Singh Kahlo.
That has been referred by everyone.
I am placing reliance on para 40, which says that if you go to illegalities committed during the period of selection, these facts have to be established. And if we take note of the word employed by the Honorable Supreme Court, established, it has to be, there has to be some opportunity given to us. If you are trying to establish, all that has been said that there have been irregularities in the manipulation and the answer scripts, etc., etc.
Yes.
I have to be put to notice, I have to be given an opportunity to put forward at least my version of the story.
Their argument is that if you are put to notice, it becomes it takes shape of an inquiry, and then it would not be an order of termination simpliciter.
That is why, my lord. That is why, my lord. My submission is my first reference was to the rules.
Yes, that's right. We have taken note of it.
If it is during the course of probation, those principles will have application. That on a prima facie satisfaction, the authorities have the right to terminate the services.
Right.
Well, we would not like to go into a detailed inquiry, and we are simply terminating your services. However, this goes to a date prior to my appointment itself, which means you are attributing some illegality during the selection process. If that be so, and going by the language used by the Honorable Supreme Court in Inderjit Singh Kahlo and also Joginder Pal, which is 2014 6 SCC 644. I am specifically relying on para 10.
Yes. Yes.
The Apex Court has said that if the allegation pertains to illegalities at the time of selection, those facts have to be established.
Yes.
And for establishing those facts, I am entitled to an opportunity. Both these judgments, in fact, Joginder Pal relies on Inderjit Singh Kalo. And so far as the other submissions are concerned, my lord, I adopt the arguments advanced by Mr. K. Chaudhary, Mr. D.K. Mishra. That's my very short limited submission.
Yes, please.
Back to the lordship. In item number 6, 8, 9, and 10, I'm adopting the arguments made by learned senior counsels, D.K. Mishra, Didas, and K. Chaudhary, sir. Lordship. That is my submission.
Okay. Yes.
Made to the lordship. In item number 17, and there, my lord, I'd like to lay down some of my initial facts, if my lord allows me. And
Which service?
APS, my lord.
APS, yes.
So, I have joined APS in the year 2015, my lord, by clearing the combined examination of 2013. And short list of dates which I prepared for reference, and the page numbers are there.
What is that extra fact which you want to point out? Everything else has been argued. Posting, transfer, completion of probation, everything has been referred to.
My lord, actually, I have been promoted. I have cleared my departmental exams, and due to my meritoriously in the service, I have received
Commendation certificate.
My lord.
Yes.
I was involved into an inquiry of an kidnapping case. So the point which I'm trying to make, my lord, is Rule 20, under which, Rule 16B, under which I was been terminated. My lord, for a moment, if my lord takes the rule,
yes,
APS rules, my lord.
APS rules.
So, Rule 16B has been invoked, my lord, for terminating me.
Yes.
So, Rule 16B says, my lord, considered otherwise unsuitable for a reason to be recorded for continuing the service, for reasons to be recorded for continuing the service by the governor.
Yes.
So, what I'm trying to lay emphasis, my lord, my records will reflect that I have passed my departmental exams. I have received my commendation certificate, and I was also made wing commander, my lord. That position is there in that short list of date.
Yes.
So if I was otherwise eligible, if I was otherwise suitable, my lord, if you find myself to be unsuitable, that rule itself says that considered otherwise. While considering, my lord, I have to be heard while considering. If the rule does not provide for an opportunity of being heard, by the usage of the word considered there, present there, the rule of audio argument part has to be read into it, my lord.
Okay.
My short point is this, my lord. One, so the submission which I'm trying to lay upon, or the proposition which I'm laying, my lord, is that if I am otherwise suitable, which has demonstrated with the fact I've cleared exams, I've been promoted and all. So on that time, my lord, if he is considering, means if the governor is considering in this case, my lord, if he is looking into the materials which have been there in front of him, he has to give me an opportunity to explain my side, to justify that I'm otherwise suitable. So the rule of audiandrum partem is inbuilt in the word considered. That is my submission, my lord.
Yes.
My short second submission is this, my lord, that I think my lord is already. That mere allegation cannot be a basis of discharging somebody from service, even if there is a case made out by the respondent, there is a violation of Article 14 and 16. For this, my lord, I I refer into the judgment of Manoj Nirula Union of India, 2014 9 SCC, particularly paragraph number 122. I'm not troubling. SCC 1, 2014
Yes.
9 SCC 1, paragraph 222. Sorry, 112, my lord. 122, sorry.
What is the proposition?
My proposition is this, my lord, that mere allegation of misconduct cannot be a basis of discharge from a service, even if there is a case made out by the respondent that there is in violation of Article 14 and 16. Because predominantly the case which has been put forward by the landed from the respondent side is this, that there is a violation of Article 14 and 16. Does this action?
Okay.
So that is the my two short submissions which I want to do. Otherwise, I adopt the submission of my landed senior, Mr. D.K. Mishra, sir, and D. Das K. One more small point, my lord. I am also one of those petitioners in WA 333 of 2021, item 40, my lord. In my case, the probationary order was backdatedly or whatever, it was extended, and it was argued by Mr. D. Das, my landed senior. I adopt his argument with regard to that.
Yes.
Anything? My lord, this is the one. Deeply obliged, my lord.
Okay. Everything, everyone from the appellant side has completed? Very well. Yes, Mr. Kohli.
Lordship, ladyship. I will lordship how I plan to take it because there are many individual cases. And with lordship's permission, I will make a few opening submissions, lordship. I will then, lordship, lead it to some core questions that I think would be relevant, lordship. Briefly, first just talk about the law. In fact, lordship already knows about it. Then I will shift to what is our core case versus what is the case on the other side. Then, lordship, I will deal with only a few facts in some of the affidavit, just for continuity. Some of it may be repetitive, so I seek your indulgence for that, lordship. And then after that, lordship, I will propose to go to a series of judgments first. They have been considered, but it's, in my respectful submission, lordship, important that we see the original judgments. Because the core point that I will profess at that time before I start building on further judgments, lordship, is that they are probationers. And that
is your case.
Exactly. I'm talking of my case.
Yes.
Absolutely, lordship. And obviously, lordship, I have the domains of Guwahati High Court, so I will take a little time on that, lordship. Lordship, this is a case in my...
So before you proceed, Ms. Kohli, can we have a look at that Gazette notification? Or your stand on it, either of those two?
So, lordship, I would first, I have sought instructions yesterday being a holiday on the Gazette notification.
The question was posed long back.
Yes, Lord.
So we assume that instructions must have been sought earlier.
Yes, Lord. I did also speak about it. A meeting was fixed, lordship. This is the Gazette notification query on the extension of the probations.
Yes. The very sanctity of that order.
Very well, lordship.
Whether it's an antedated, post-dated, what is the nature?
Lordship. And my argument to that is, which is would have been argued also.
Before you argue, sir, make a clear statement whether it
yes,
was
lordship,
Gazette
I'm coming on record.
Yes.
Nothing beyond that. Is that dehose the notification via our cases?
Mr. Kohli, first a clear answer whether it
Yes,
was
lordship,
gazetted or not. Simple. Then we'll hear everything you want to say.
My instructions, lordship, are
yes,
that it was sent for publication. There seems to be lack of clarity whether it was published at all. I don't think it was.
So, all right.
And that's why I said I'm seeking the final instructions today. That it was sent for publication, but I don't think, because I'm not convinced myself, lordship, as an officer of the court, that it was published at all. And of course, I will deal with that aspect also.
That is a
different aspect.
Aspect at all,
yes,
entirely.
But definitely there was an order, it was sent out. So I had asked them to check on the dispatches also, lordship. That is why I was seeking time on that. But what I've seen yesterday, I'm not convinced it was published, but subject to my final instructions that it was sent and what was the dispatch status.
Yes.
Those hopefully by the end of the day I should have, Lordship.
Yes, please.
So, Lordship, essentially, Lordship, the APSC cash for jobs scam
Yes.
really started with a complaint of a Dr. Anshumitra Gogoi, who was approached by a tout. A demand was made that if you pay the amount, you will get a guaranteed job, irrespective of how you perform in the exam. That complaint eventually led to the filing of the Dibrugarh FIR 936 of 2016 or in October 2016. There followed a detailed investigation. The investigation, Lordship, clearly exposed a shocking modus operandi, Lordship, of a colossal scam where in an organized manner, government jobs were being sold literally on a rate card, 10 lakhs to 50 lakhs. Smaller the amount, the service was treated as less important. Higher the amount, APS, AP, the police service or the civil service. Now, Lordship, how did the scam really operate? And why this scam, in my humble submission, is also a little different. Scams in jobs is not new. Scams in jobs have bothered several states and have received judicial notice, interpretation, judgments in detail over the decades. But this scam was a little bit different because, respectfully, human ingenuity, Lordship, with criminal intent can break even what are considered sometimes the strongest locks to protect a system. Here, the mastermind was the chairman of the APSC. We know that. The modus operandi was he had a set of touts who were government employees, either in the APSC or in departments like the Urban Development Department. These touts or agents on his behalf, through a network, contacted those who had sat for the exam or going to sit for the exam. They were assured that on the payment of a bribe, what would happen was eventually, irrespective of how they performed in the exam, they would get a second chance at rewriting their paper. To rewrite that paper, being the head of the commission, from the strong room, the original answer sheet was taken out. The brother of the chairman of the APSC ran a private printing press. Duplicate answer sheets blank were printed in that press. The candidates now, in their own handwriting, rewrote an exam.
Where was the original set printed?
Government press. We can bring that on affidavit also, Lordship. I'm carrying those loose sheets.
Okay.
So that RTI reply, which was professed by one of the seniors, but no, Lordship, he printed the duplicate answer sheets.
Okay.
These answer sheets, Lordship, were refilled and then sometimes including the chairman of the commission signed as the invigilator. So obviously there would be no match with the invigilator of the day. The papers were printed as per a proper look and the examination was replaced into the strong room, Lordship. This is what the investigation revealed, and the investigation went a step ahead to forensic audit. To look at handwritings, to look at the signatures of the invigilators, and all of it confirms. The writ petitioners, Lordship, before the learned single judge, before Lordship and Ladyship, are those participants who were willing to do so, who paid the bribe money, Lordship, rewrote the exams, scammed the system, as I would respectfully say, Lordship, and became the identified beneficiaries of the investigation. They were identified, Lordship. In what we have been consistently held throughout, Lordship, being a colossal scam and a fraud. That's been our stand from the single judge, Lordship. These identified beneficiaries, Lordship, and I make a point because various things are professed on the rights under part chapter 3, Lordship, in terms of the fundamental rights. But these identified beneficiaries eventually got appointed to public office. And respectfully, Lordship, at the cost of those who genuinely sat for the exam. The numbers are large. I will touch upon it little later, Lordship. And I would also argue, what about their fundamental rights, their legitimate expectations? After all, they worked for an exam. Now, Lordship, which is where the question next comes, what are we looking at? We are talking of an appointment to a public office. The one who gets appointed is a public servant, meant to serve the public and meant to serve the public interest. This is not about personal interest, it cannot be. This is an obligation also on the state to give a clean and efficient administration.
Right.
Imagine, Lordship, and this is a question to myself, someone who has paid an illegal gratification, managed to get an appointment, mans a responsible post, the public has to deal with them without knowing that that person is on a question of a bribe or a scam. What is going to be the administration? And on vice versa, if they are to continue in office with a taint, what will be the fate of the public or the public interest in terms of their discharge of their duty? This is the stand we took in our arguments.
Yes. Can anyone give a guarantee that a person properly selected would continue to work without that taint?
Lordship, we are on, unfortunately, I wear another hat, Lordship, in which there is no guarantee on everything I do.
Okay.
And Lordship, sometimes I joke and say, some people may also wish to wash their hands with sanitizer if they shook my hands, because that is the taint that comes on us for being part of another system. But Lordship, that is the reality. And I know where Lordship is coming, and there's no argument with that. Lordship, so the fundamental questions in my respectful submission, Lordship.
Yes, all right.
The first is, what is the infraction of what fundamental right are they agitating? What is that infraction of what fundamental right that they are agitating? What is the public interest that they are seeking will be served in their expectation of a mandamus under the writ jurisdiction?
Yes.
Because I will later on show a judgment, Lordship, which we found subsequently of the full bench of Patna High Court, Lordship, which also deals with the issue of a mandamus under the writ jurisdiction. Third, Lordship, can the personal interest of one who invokes the equitable writ jurisdiction of this honorable court be protected against the larger public interest? Fourth, Lordship, which has been very, very in detail and in my humble submission beautifully dealt with in the learned single judge's judgment, can the rules of service be invoked for one whose very entry into the service is tainted?
Yes.
And the corollary or the parallel argument with that is, can the rules of service be invoked for a misconduct at the point of entry as compared to a misconduct during discharge of duty after a bona fide entry? These are the two parallel arguments, Lordship. Misconduct after bona fide entry, misconduct at the point of entry. And in that, I would also respectfully argue, Lordship, what is the legal infirmity that has been raised in the judgment before in challenge? There has to be a legal infirmity. Because what that judgment has essentially held, Lordship, is a tainted entry of a probationer. And that's the core of my argument, Lordship. The probationer does not give them any right. Gives them no protection, no right, much less fundamental right, Lordship. Under service rules meant for the bona fide entry of a person and for misconduct that follows a bona fide entry. So, Lordship, just to give the overview in 4 or 5 sentences, as the law has evolved, Lordship, and series of judgments, we will touch some of them, Lordship. Lordship is aware. In fact, Lordship himself was pointing out the relevant paragraphs that I would have sought to rely on.
Yes.
Is that the law as it has evolved, Lordship, is on 2 points. If there is a question on the examination, with regard to a scam or any kind of indulgence of any unfair practice. As if you cannot identify and segregate the tainted, scrap the exam. It's settled law, Lordship. Whether it is school teachers, public servants, whatever, in state after state, Bihar, Punjab, Haryana.
Yes.
But if you can segregate, as the word uses, the grain from the chaff, then you don't scrap the whole exam. And that also, Lordship, is founded on the point that many genuine people who did not scam the system worked for it, sometimes in their third attempt, fourth attempt. Make it, you're doing great disservice to their effort, Lordship, and they have rights also. So, Lordship, in this background,
yes,
what are our core submissions? Is that the first, Lordship, and I'll build on them through the judgments later. The state has proceeded strictly in accordance with the law laid down by no less than the Honorable Supreme Court. We have proceeded in accordance with the settled law. And specifically, Lordship, Krishan Yadav, O Chakradhar, Joginder Pal Singh, which follows Kelo. Kelo is a case that has been referred to multiple times. It had a lot of back and forth, but eventually, Lordship, Joginder Pal is the final in the series, and that's where the tainted was segregated, and Justice Sikri's para 19, if I recall, was where Lordship had also marked it. The second is, Lordship, our action of discharging the probationers was based on cogent material that became available to the state following a thorough investigation about a colossal fraud and scam to gain illegal entry into the service. So there was cogent material, outcome of a detailed investigation that the state had access to, and that's why it took action. And in light of the facts that came before the state was obligated, Lordship, to segregate the tainted and take action against them.
Yes.
This action was only against the identified beneficiaries, only against them. The action of the state, Lordship, was bona fide to restore public trust in public office.
Yes.
To restore public confidence in the administration. Our stand has been, Lordship, when the entry itself is tainted, they have no rights because what they have got is void ab initio. That's our stand. Because it's fraud unravels everything, Lordship. And if the entry is tainted, Lordship, they can't claim violation of any right, much less a fundamental right. There can't be protection under fundamental rights to claim benefit after you have scammed the system. Second, Lordship, the parameters of judging what may be called a misconduct for a bona fide entry into service cannot be compared with a tainted entry into the service. They are different parameters. They are incomparable. We are serving or attempting to serve the doctrine of public trust in public office, which means the doctrine of public trust would call upon the occupier of the office, public office, to be free from blemish.
Yes.
Much less being an accused and identified beneficiary of a scam. We are at the stage where charges have been framed also, Lordship. So therefore, Lordship, their appointment was, their continuation in office was unsustainable. They were probationers. The state had the power to discharge them. We quoted the General Clauses Act also, the power to appoint has the power to discharge Lordship, the rules also. And Lordship, finally, being probationers and temporary, the state being obligated to take such action did so in public interest. That's the crux of my case, Lordship. If I look on the other side, Lordship, and I'm not singularly responding yet, Lordship, the facts are against them, and in fairness to the learned seniors who've argued, they've also acknowledged that the facts are not in any way helpful. But Lordship, they are unable to show a single judgment where they can claim that in these facts, indulgence was received and should be received. Palak Mode, Lordship, is distinguishable. And Lordship also was pleased to comment on that. That was about the confirmation of the examination of a probationer at that stage, but the entry was bona fide. They don't have a single judgment, Lordship, to rely on of any court that if the entry is fraudulent, Lordship, if that entry is tainted, the state is obligated to continue with their service. There's no judgment to that effect, Lordship. There's no judgment also, Lordship. A corollary of that would be that their continuation in office is in the interest of public interest. This is, Lordship, and they haven't been able to assail the reasoning of the learned single judges. Detailed and thorough judgment, Lordship. So, with that overview, Lordship, just for completion of facts, I had, Lordship, so before I rely on those documents, requested my colleague Dipankar had shared it with Lordship's courtmaster that I would be primarily arguing at the end with the Pallavi Sarma Chaudhary's case, which is Writ Appeal 75, but it's only for the final judgment, Lordship, that can be referred in any appeal because I will refer to the paras. Then, Lordship, there is one compilation, and D.K. Mishra sir had been very indulgent on multiple occasions to refer to that affidavit and compilation, which was in the Kunal Das case, Lordship. I'm told that the single judges that compilation, but in the writ appeal, we have annexed that. So if we take the Kunal Das case, which is item number? 13. So Lordship, in that, I'm only going to refer to 2-3 annexures, again for completion of facts. Because the rules are also all annexed in that one single compilation. Kunal Das, we had given a consolidated affidavit and we gave a convenient sort of compilation so that all the rules, everything are annexed in one place. Lordship.
You're referring to Kunal Das right now only?
Lordship,
or Pallavi Sharma also?
So, I beg your pardon.
You'll be referring to the file of Kunal Das
You can
or
also
Pallavi Sharma?
Kunal Das, because Pallavi Sharma I'm using only for the judgment. Kunal Das can help. The same
Judgment, we have got a separate copy.
I will, yes, Lordship. So
Yes.
Kunal Das would be useful, Lordship.
128 of the 20.
Yes, Lordship. Deeply obliged.
Yes, please.
So, Lordship, just on a few facts, is that the 2015 batch, Lordship, it means the 2013 exam. And the 2013 exam, 45,000 people approximately sat for the exam. It's also, Lordship, there in the single judge's judgment. Of which out of 45,500 people who appeared in prelims, 2,300 approximately appeared in the mains, Lordship. Almost 500 were called for the interview, 497 to be precise, and 241 were selected. So the figure finally that comes in the 2015 batch, Lordship, are 241 selected against 45,553 who appeared. The 2016 batch being the 2014 exam, Lordship, 24,722 appeared in the prelims, and finally 180 were selected. So, Lordship, between the two batches, 421 were appointed in 2015 and 2016, Lordship. In the ACS, which is the civil service, the APS, the police service, taxation, transport, and labor. These are the petitioners. Now, Lordship, when the scam came out, besides the media bureau, there was an occasion for this honorable court also to deal with it at the preliminary stage. And what had happened, Lordship, a PIL was filed, dear Lordship. It's part of the record of Kunal Das. I'll show Lordship. And what happened in that PIL? Originally, the demand was to scrap the entire examination.
Yes.
Because also those who were unsuccessful in the examination had raised that demand. At that time, Lordships felt that this should be referred to the CBI.
Yes.
And a preliminary inquiry was ordered, which eventually, Lordship, became a final registered case of the CBI. And those Lordship are part of the Kunal Das in that compilation, Lordship.
That doesn't relate to this set of selection.
Yes, no, Lordship. This all raised to the fact of the exams, which is current one. They were against Rakesh Paul, who was then the chairperson. The examination scrapping was called for these ones only, Lordship. So it had been considered, Lordship. Out of that emanated something which Lordship asked, and I will eventually answer, is the B.K. Sharma Commission of Inquiry. That all emanated from that PIL, Lordship.
Yes.
So demand for scrapping, B.K. Sharma, CBI, all of it happened over 2 orders, Lordship. During that period, Lordship, second thing was there that at that time, because he was the serving chairperson, a presidential reference was there under Article 317. And that is on record. So that sums up all the things that were available at that time. And that is the document that I wish to show, Lordship. That would be in the Kunal Das 1, Lordship. So it would be 188. Presidential reference. Just give me a moment, Lordship. I'll just give the exact page because I'm holding the original 185, Lordship. Kunal Das, Lordship, reply. Writ appeal, Lordship. Has Lordship got Kunal Das writ appeal, Lordship?
Yes, it will happen.
So in the reply, Lordship, in the appeal, I'm begging your pardon. 185 in the appeal, Lordship.
Yes. 28 May 2017.
Yes, Lordship, I am seeking Lordship's indulgence for a minute because my pages are separate. So just a moment, Lordship, respectfully. 6. Mark 83, ये था, अच्छा, 56. Yes, Lordship, that's 28th May. And I'll just read, Lordship, some parts of it only. Whereas so-and-so, the Honorable Governor, by his letter of November 22nd, 16, has requested making a reference to the Supreme Court of India under Article 317(1) of the Constitution for conducting an inquiry against so-and-so, the chairman of the Assam Public Service Commission. Whereas the Governor of Assam has further submitted that so-and-so has been arrested by police on the ground of corruption, and the investigation that followed has gathered sufficient evidence towards proving his involvement in corruption in Assam Public Service Commission as observed by the Special Judge Guwahati who heard the case. When Lordship may turn the page, in the second paragraph, it only notes his arrest on 4th of November 2016, Lordship, in the Dibrugarh case. Then Lordship, leaving one paragraph, the 4th para on the page, whereas a search operation was conducted in the house of the person and some incriminating documents relating to corrupt practices in the Assam Public Service Commission were recovered. Whereas the police has recovered answer sheets from the house of Sri Rakesh Kumar Paul, along with the other relevant documents related to APSC. The answer sheets were found separately evaluated and without roll number of the candidates. This is all part of the presidential reference, Lordship. Last para on the page. On further interrogation and search and on being led by so-and-so, the police has also recovered some incriminating documents, that is the Assam Public Service Commission answer scripts, along with the relevant documents relating to the APSC from the premises of one Shubhodip Printers. This Lordship is his brother, whose printer press, who's even today absconding, Lordship. We've never been able to find him or arrest him. Which belongs to one so-and-so, brother of the accused in this case, and the same has been seized. The investigating officer also seized 20 numbers of APSC answer books and APSC logo and instructions, 7 numbers of master paper from the premises of Shubhodip Printers at Bhangagarh, Guwahati. Last 2 paragraphs, Lordship. And whereas after going through the material placed before me, I am satisfied that a prima facie case exists for an inquiry into the charges made out in the reference by the Governor of Assam. And now, therefore, in exercise of the powers conferred upon me under clause 1 of 17 to 317 of the Constitution, I, at that time, Honorable Pranab Mukherjee, sir, President of India, hereby refer to the Supreme Court of India for an inquiry and report as to Mr. Rakesh Paul, Chairman, Assam Public Service Commission, ought, on the grounds of malpractice and corruption, be removed from the. So this was placed at that time. There's consideration. This is not a blind forward. So there was enough material that was
What
happening.
happened after that?
So, Lordship, I appeared on the last date. What has happened?
Still
is-
continuing.
Yes, Lordship, it got put in. And now, Lordship, he has super actually. And
That's right. That's.
So
his
therefore
tenure has
that-
come to an end.
and it was before the Honorable Chief Justice's court. And I brought this factum before Honorable Chief Justice. And he then also asked whether we need to continue with it. And that instruction, the other side's lawyer had to take. In fact, respectfully, with a flux of time, it's over. He was given bail after 6.5 years earlier in March. So now the question is, if he's fighting on post-retirement benefits, perhaps he may need to agitate it. But otherwise, it's infructuous in terms of afflux of time. So this, Lordship, was just the background of that. Now, Lordship, in this we have, let's show 86. What is the page here? Which was this, not compilation of rules. No, 236. No? Which was the, will tell Lordship the page, this here, chart, Annex chart. Lordship 236. That is Annex R9. I will just check your page, Lordship, for a moment. Annex R9. Just bear with me on two documents, Lordship. After that, I don't really have much documents.
R9 you are referring?
Yes, Lordship, R9. My page is 236 in the original affidavits.
Not matching this.
Yes, Lordship. That's why I'm asking.
We'll search, don't worry.
On
What is the document? Just
document, Lordship, is appointment orders. It's an index, Lordship.
There's a complete set of rules.
Yes, Lordship.
It is-
After the rules that comes.
After the rules.
Yes, Lordship. After.
So,
I will be coming to the rules after this.
not really they. Uh,
373, Lordship.
is it 15th October 2016?
No, Lordship. Actually, it's a chart like this, Lordship. And they are telling me 300 and. No, turn pehle. Isse pehle hoga. It's before this. We are there, right? We are there. Ankit, tum dekh na. That. We got it, Lordship. That's 365, Lordship. We made a table, Lordship, so it becomes easier instead of referring.
Yes. All
That
right.
is. I will again at lunchtime, Lordship, my colleague will assist.
Yes, it's
I'm sorry.
appointment orders.
Yes, Lordship.
Yes.
So, Lordship, what I'm actually pointing out is Lordship may note the appointment orders and the date is there. And what I will show, Lordship, is that everyone's discharge is within the period of their probation. Now, Lordship, I'm just pausing for a minute, Lordship. Essentially, Lordship, and we'll show judgments to that effect very shortly. All of them were appointed either as probationers or temporary. The word is used.
The word is used temporary in some of the.
In some of the orders. Second, Lordship, under the rules of all the services, it provides for two scenarios, Lordship. A 2-year probation, followed by an extension of, in most cases, a 2-year additional extension, followed by the requirement of a formal confirmation. Now, Lordship, the law on that also is settled, which we will show, is that if you are on probation and there is no positive satisfaction in writing, you are deemed to be on continuation of probation up to the maximum period at the very least. In this case being 4 years, Lordship. And all of them have been discharged within 4 years.
Okay.
So my argument is from the beginning, they are probationers, temporary. Lordship may just note just one order. 230, the next page, Lordship may just turn the page. 367, Lordship. That's 12th August 15. This is Lordship of ACS, and the word on the 4th line is probation. 246 क्या करेगा तुम्हारे ये कौन सा पेज है 367 367 so I'm 238 238 को माइनस करना पड़ेगा 246 ठीक है गुड 246 बोले this is page page So Lordship, I'll make the submission because it's on record. Don't bother. We'll mark the pages in lunchtime and give the note. Lordship, this is the police. In the police, Lordship, the word probation is not there in the initial appointment, Lordship. 383, Lordship. Police. In this, Lordship may note the word probation is not there on 383, Lordship. But the rules provide for probation.
Yes.
That is the point I'm making. Lordship, taxation is on 383.
Taxation or police? Taxation.
Taxation. Lordship.
Police is not at.
Yes, Lordship. Sorry, I took you to the long page. I apologize for that. It's temporary, Lordship. Taxation uses the word temporary. The preceding ones of the police don't use the word temporary, Lordship. Taxation is the word temporary. And just Lordship, 8 pages ahead is the labor, Lordship. Transport, Lordship. Again, the word is temporary. 389 it is, Lordship. And the very next page, Lordship, is labor, where the word probation is used. So essentially, Lordship, there are 2 temporaries, 2 probations, and in one service, the word probation is not used, but the rules provide for it. So we have to only now see the 5 relevant rules. Rule started 86 tha yahan pe, udhar kya? Direction. For the compilation, I got a separate copy made just in case it's not raised. So this is the only document I'm applies for that indulgence of a little bit of confusion. That's it.
Not
215 in Lordship's memo of appeal, Lordship. And now we have to go to page. We are on ACS. Rule 22. Lordship. 229, Lordship. Rule 22, Lordship. Has Lordship got Rule 22?
222 or 229?
229, Lordship. Rule 22.
Yeah.
So, Lordship, in this case, it says probation and confirmation. A member of the service shall be placed according to seniority on probation for a period of 2 years. So 2 years is specified, Lordship. Provided that the period of probation may for good and sufficient reasons be extended by the governor in individual case for any period not exceeding a period of 2 years. So 2 plus 2. And then, Lordship, it also says the proviso provided that the period of probation may be curtailed or dispensed with in any case for good and sufficient reason for the appointing authority. Next, Lordship, 2 is very important. A member of the service placed on probation under Subrule 1 shall be confirmed against the permanent vacancy subject to the following conditions. And A, he has completed the period of probation to the satisfaction of the appointing authority in accordance with Rule 1, and he's undergone the training. So therefore, Lordship, 3 things are there. 2 years, extendable to 2, which means 4 years total, and not a condition that can be dispensed with, a positive satisfaction for confirmation. Then, Lordship, the police rules. 103 का उसके सीधा rule पे आ जाओ. 189 police rule. 238, Lordship, is probation 15. Yes, Lordship. Police rules, the probation is Rule 15 at 238, Lordship. Now, this Lordship is slightly different. That's why I'm showing it so that the facts are all covered. May I read, Lordship? All persons recruited to the service shall, except persons recruited under Rule 5(2), be on probation for a period of 2 years from the date of appointment to the service. So 2 years provided. The period of probation may, for good and sufficient reason, be extended by the governor in individual cases by such period as deemed necessary. It's open-ended.
Yes.
Then, Lordship, we'll go to taxation. 263, Lordship. That is the rule you're looking at. That is Rule 21, Lordship, at 263. Taxation, Lordship. May I read, Lordship?
Yes, yes.
Again, probation and confirmation. Subject to availability of a permanent vacancy, a member of the cadre of the Superintendent of Taxes and Inspector of Taxes shall be placed according to seniority on probation for a period of 2 years before he is confirmed against a permanent post, provided that the period of probation may be, for good and sufficient reason, be extended by the appointing authority for any specified period not exceeding the period of 2 years. Again, 2 plus 2, Lordship. And then we can go to 2A, Lordship. Basically, 2 will read, a member of the service placed on probation under sub-rule 1 shall be confirmed against a permanent vacancy subject to the following conditions. A, he has completed the period of probation to the satisfaction of the appointing authority. So the requirement of this. Then, Lordship, the transport. 287, Lordship.
Yes.
That is 21, Lordship, again. And Lordship may just mark. Transportation also follows, Lordship, in 21. 2 plus 2 plus the requirement of a positive satisfaction. And Lordship, labor 302, Lordship.
Yes, please.
Yes, Lordship, that is 12. Probation, Lordship. Again, Lordship, it clearly provides for a 2 plus 2. Not exceeding 2 years. So, Lordship. And Lordship, if you'll turn the page, 14 deals with the confirmation separately, Lordship. Which says where the probation is completed to the satisfaction.
Yes.
So, Lordship, basically having shown the rules, and before I go to the judgments, Lordship, I'm basically only establishing, Lordship, that they were all probationers, which could have been and are deemed to have been on probation because there is no positive satisfaction of their confirmation. And all of them were, Lordship, discharged prior to 4 years. So therefore, Lordship, on both counts, being the availability of a probation period up to 4 years, and they being discharged prior to that, and the lack of a confirmation letter in their favor, makes them probationers and temporary out and out, and the state has validly, therefore, exercised its right under the rules. Now, Lordship, in this, why I'm raising it? Because an argument of increment had been raised. And also the reduction of the period of serving in a battalion in the police. Respectfully, Lordship, that does not change their status in any way because they were probationers and there was no letter of confirmation of their service as permanent employees. So this was to deal with that argument, Lordship.
Yes.
Now, Lordship, I'm going through the compilation, Lordship. If that is not available, we'll give a copy. No, I served Lordship. So, Lordship, we had actually given 4 compilations. I'm referring to 3, Lordship. Just assist, Lordship. Your court master. Giving it, yes. 2 copies? Pages are the same. No? So I thought, Lordship, I'll start with the probation part only.
Yes.
Let me overcome that hurdle and then go backwards on the other thing. And Lordship, our proposition is if the applicable rules provide for extension of probation, no person can claim deemed service, confirmation in service, unless a specific order of confirmation is passed by the competent authority. And this proposition, Lordship, has been dealt with several judgments. And on the index, Lordship, I'll just say 1, 2, 4, 6. Basically, G. Ramaswamy, Pratap Singh versus Union Territory of Chandigarh, Satyanarayan Athia versus MP, Qazi Muhammad Muzamil versus Karnataka, and Durgabai Deshmukh, Lordship, which is the latest. I'll start with the first judgment, Lordship, which is G. Ramaswamy. The pages are same, Lordship. So it's a 5-judge Lordship of 1964, Lordship, Constitution Bench. I'll give the citation. Please note, they are all part of the compilation down, but 1964, 6 SCR 279. This is G. Ramaswamy versus the Inspector General of Police, Mysore State. The Lordship, this is to do with the division of the state at that time. Para 2, Lordship. I'll only take Lordship to the relevant parts.
Yes.
The case before the High Court was briefly this. All the petitioners were appointed as sub-inspectors in the former Hyderabad state under Section 6 of the Hyderabad District Police Act. Under Rule 399 of the Hyderabad District Police Manual, issued by the Government of Hyderabad under Section 10 of the Hyderabad District Police Act, posts of circle inspectors were to be filled by promotion from the rank of sub-inspectors. Then Lordship may move down by about 10 sentences. In the middle of the pages, the case of the petitioners in the High Court. Has Lordship got that?
Yes.
Thank you, Lordship. The case of the petitioners in the High Court was that their names were included in the eligibility list published in the month of October 1956 before the States Reorganization Act came into force on November 1st, 1956. They therefore contended that in view of the entry of their names in the eligibility list, they were entitled as of a right to promotion to the post of Circle Inspector as and when vacancies arose. Para 4, Lordship. The petitioners continued to serve in the new state, and as they were in the eligibility list referred to above, they were promoted as circle inspectors in various dates after November 1st. Second last sentence, Lordship. It also appears that pending integration promotions were made from these eligibility lists ad hoc or when they were called out of seniority and continued to be so made pending integration. The petitioners were thus promoted ad hoc circle inspectors from the eligibility list received from the former Hyderabad state and continued to act for varying periods as such. It further appears that the petitioners were ordered to be reverted when certain confirmed circle inspectors who were on leave or on deputation outside the state returned to the new state. Thereupon, the petitioners filed writs before the High Court in which they claimed that they had been put in the eligibility list by the former Hyderabad state. They were entitled as a right to promotion as circle inspectors and to continue as such thereafter. An order of their reversion amounted to reduction in rank. They therefore prayed for a writ, order or direction, quashing the orders dated so-and-so, ordering their reversion and directing the state government to continue them as circle inspectors. Then, Lordship, para 7 on the next page. The first two questions that fall for consideration are whether the fact that a sub-inspector's name is put on the eligibility list gives an indefeasible right to him to claim promotion, and whether after such promotion on a temporary or officiating basis, he gets a right not to be reverted under any circumstances. We are of the opinion that the fact that a sub-inspector's name in the eligibility list gives him no right of the kind urged on behalf of the petitioners. Then, Lordship, about 12 sentences down, Lordship, on the right-hand side, it starts with, it follows, therefore, that the mere fact that the sub-inspector's name is once put on the eligibility list does not give him an indefeasible right to promotion as a circle inspector. Then there is Rule 486, which governs promotions generally. It lays down that promotion cannot be claimed as a matter of right, though officers and men of all ranks are entitled to expect promotion if they have good records and if they are smart and efficient and have a thorough knowledge of their duties. This again clearly shows that merely because a sub-inspector's name is put on the eligibility list, he cannot claim promotion as a matter of right. Rule 486 further provides that all officers who are promoted will be on probation for a period of 2 years. They may be reverted at any time during this period by the competent authority to promote them if their conduct and work is not satisfactory, or if they are found unsuitable for the appointment to which they have been promoted. This clearly shows that even where a sub-inspector has actually been promoted as circle inspector, he remains on probation for 2 years, and during that period, he is likely to be reverted if his work and conduct are not found satisfactory. This again negates the contention on behalf of the petitioners that they had an indefeasible right to promotion because their names had been put on the eligibility list and they could not have been reverted once they had started acting as circle inspectors. Lastly, Rule 486 provides that the promoted officers will be confirmed at the end of their probationary period if they have been given satisfaction. This clearly shows that it is only when the probationary period is over and the promoted officers have been given satisfaction during the whole period that he will be confirmed. It is clear, therefore, reading upon rule so and this, together, that the mere fact that a sub-inspector's name is put on the eligibility list does not give him any indefeasible right to promotion. Further, the fact that he's actually promoted temporarily or as officiating does not give him any right to continuance, even during the period of 2 years probation, and he is liable to be reverted back at any time during those 2 years if his work is found unsatisfactory. It is only when the authority concerned has found that his work and conduct are satisfactory during the probation period that he can be confirmed. The contention of the petitioners that they had any right under the eligibility list for promotion or that they had actually been promoted, they had a right to continue in the post of circle inspector, therefore must be negative. Para 8. It has further been urged on the basis of Rule 486 that as the petitioners had worked for more than 2 years on probation, they became automatically confirmed under the said rule. And reliance is placed on the following sentence in Rule 486, namely, promoted officers will be confirmed at the end of their probationary period if they are given satisfaction. Now, Lordship, this is quite parameteria in terms of our facts, though this is promotion. The law on the question has been settled by this court in Sukhbana Singh versus State of Punjab. It has been held that in that case, that a probationer cannot, after the expiry of the probationary period, automatically acquire the status of a permanent member of a service unless, of course, the rules under which he is appointed expressly provide for such a result. Which means, Lordship, if there is no positive requirement of a letter of confirmation and the rules say that it is not required and you will be confirmed after probation, that case is different. That is not applicable to us. Therefore, even though a probationer may have continued to act in the post to which he was appointed on probation for more than the initial period of probation, very important, Lordship, he cannot become a permanent servant merely because of a flux of time. Unless the rules of service which govern him specifically lay down that the probationer will be automatically confirmed after the initial period of probation is over. It is contended on behalf of the petitioners before us that part of the Rule 486, which we have set out above, expressly provides for automatic confirmation after the period of probation is over. We are of the opinion that there is no force in this contention. It is true that the words used in the sentence set out above are not that promoted officers will be eligible or qualified for promotion at the end of their probationary period, which are the words to be found often in the rules in such cases. Even so, this part of Rule 486 says that the promoted officers will be confirmed at the end of their probationary period. It is qualified by the words, if they have been given satisfaction. Clearly, therefore, the rule does not contemplate automatic confirmation after the probationary period of 2 years for a promoted officer can only be confirmed under this rule if he has given satisfaction. And Lordship remarked, the condition of giving satisfaction must be fulfilled before a promoted officer can be confirmed under this rule. And this condition obviously means that the authority competent to confirm him must pass an order to that effect, that the probationary officer has been given satisfaction and is therefore confirmed. The petitioners therefore cannot claim that they must be treated as confirmed circle inspectors simply because they have worked for more than 2 years on probation. They can only become confirmed circle inspectors if an order to the effect has been passed under this rule by the competent authority. The first contention, therefore, that the petitioners before us have an indefeasible right to promotion once their names are put in the eligibility list and that they are entitled to continue as circle inspectors thereafter if they have once been promoted on temporary or officiating basis cannot be sustained. So, Lordship, this is quite similar to our rule situation. So I'm only pointing in terms of building the case that they continue to be probationer. The next judgment, Lordship, is on page 9. This is 1979, 4 SCC 253. Again, Lordship, this is a 3-judge. Pratap Singh versus Union Territory of Chandigarh, Lordship. Very short judgment, Lordship. First para itself. The appeal by special leave is directed against the judgment of the Punjab and Haryana High Court, dismissing the writ petition filed by the appellant against the order of his termination passed by the Senior Superintendent of Police. The appellant was appointed in July 1973 as a temporary Assistant Sub-Inspector of Police. On 26 September 1977, his services were terminated by the Senior SP. Against this order, the appellant moved the High Court of Punjab and Haryana, but his petition was rejected. Thereafter, he came to this court after obtaining special leave from the court. The appeal has been placed before us for hearing. The short point taken by the appellant in this appeal is that under Rule 12 of the Punjab Police Rules, the petitioner must be considered to be on probation for a period of 3 years. And as the appellant had crossed this period of 3 years, he must be deemed to have been confirmed and therefore his services could not be terminated. So he's claiming maximum period is crossed. In our case, maximum period is not crossed. But let us see, Lordship, what Lordships hold on this. In support of his submission, reliance is placed of the appellant on a division bench judgment of this court, and he quotes the judgment. Para 3. It is true that the observations made by this court support the contention of the appellant to an extent. But in our opinion, the division bench decision has not correctly decided, as it has not considered the 5-bench decision of this court in State of Punjab versus Dharam Singh. And that, Lordship, is quoted again and again in several judgments. This court has consistently held that when a first appointment or promotion is made on probation for a specified period, and the employee is allowed to continue in the post after the expiry of the period without any specific order of confirmation, he should be deemed to continue in this post as a probationer only. So therefore, they cover both situations, probation, promotion. In the absence of any indication to the contrary in the original order of appointment or promotion or the service rules. In such cases, an express order of confirmation is necessary to give the employee a substantive right to the post, and from the mere fact that he is allowed to continue in the post after the expiry of the specified period of probation, it is not possible to hold that he should be deemed to have been confirmed. The reason for this conclusion is that where on the completion of the specified period of probation, the employee is allowed to continue in the post without an order of confirmation, the only possible view to take in the absence of anything contrary in the original order of appointment or promotion or the service rules is that the initial period of probation has been extended by necessary implication. So, Lordship, this I was a judgment also to Lordship's query. That by necessary implication, irrespective, Lordship, without prejudice to the fact that I will answer Lordship on that Gazette thing, they are deemed to be on probation in the absence of a specific confirmation. So that order or its issuance, lack of issuance, doesn't change the nature of what they are. Probationers, temporary, up to the maximum period at the very least. Plus, of course, Lordship, the argument in our case is that an additional order of confirmation is needed. Para 4 simply says, Lordship, that he was appointed. It upholds on Dharam Singh, Lordship. And finally, Lordship dismisses it. I'm not reading to it because that's the core part, Lordship. Page 15, Lordship. This, Lordship, is 1996, 1 SCC 560, Satyanarayan Athya versus the High Court of MP. This, Lordship, will be also relied upon in one of my later judgments by Lordship Chandrachud. Para 2, Lordship. Again, very short judgment, Lordship. He was appointed on probation as a civil judge, Lordship, in 1979. On completion of the 6 months period, he was put on probation. Though 2 years period had expired, no order of confirmation was issued and he continued on probation. In view of the non-satisfactory nature of the service, the full court decided that he could not be confirmed. And orders were passed, Lordship. He appealed on it. And para 3, the question therefore is whether the petitioner has been deemed to have been confirmed after his completion of 2 years on probation under Rule 24 of the MP Judicial Services Rules, which provides every candidate appointed to the cadre shall undergo training for a period of 6 months before he is appointed on probation for a period of 2 years, which period may be extended for a further period not exceeding 2 years. The probationers may at the end of their period of probation be confirmed subject to the fitness for confirmation and for having passed by the higher standard all such departmental examination. So this is similar, Lordship, 2 + 2 plus confirmation. A reading thereof would clearly indicate that every candidate appointed to the cadre shall undergo training initially for a period of 6 months before he is appointed on probation for a period of 2 years. On his completion of the 2 years, it is open to the High Court either to confirm or extend his probation. At the end of the probation period, if he is not confirmed on being found unfit, it may be extended for a further period not exceeding 2 years. And Lordship may note, it is seen that though there is no order of extension, it must be deemed that he continued on probation for an extended period of 2 years. On completion of 2 years, he must not be deemed to be confirmed automatically. So the deeming fiction is on the continuation of probation, not confirmation. There is no order of confirmation. Until the order is passed, he must be deemed to continue on probation. Para 5. Under these circumstances, the High Court was justified in discharging the petitioner from service during the period of his probation. It is not necessary that there should be a charge and an inquiry on his conduct. Lordship is very important for us. Not necessary that there should be a charge and an inquiry on his conduct, since the petitioner is only on probation, and during the period of probation, it would be open to the High Court to consider whether he is suitable for confirmation or should be discharged from service. In this case, there was no investigation, police investigation. The court, in its wisdom, said we will not continue. Much higher pedestal than ours, a much lower pedestal than ours, because ours is at a higher pedestal. Here also, the Honorable Court held, not necessary for a probationer to have an inquiry. This is the argument that keeps coming. They should have been heard. I will deal with it subsequently, the doctrine of empty formality. That it's not a right in that sense, and certainly not in these cases. So therefore, this Lordship squarely covers our case. Page 29, Lordship.
Yes.
I hope I'm not going too fast, Lordship.
No, it's okay.
So Lordship, this is 2010, 8 SCC 155, Qazia Muhammad Muzammil versus State of Karnataka. It's two judge Lordship, page 36. So Lordship, the first paragraph merely says that he was a practicing advocate, got appointed as a district judge Lordship under the Karnataka Judicial Services. He was posted as the first additional city civil and sessions judge of Bangalore. It is his case that he performed his duties with utmost diligence and had an excellent track record. His rate of disposal of the cases was very good. The High Court had scrutinized his performance, and neither any adverse remarks were communicated to him, nor any memo or showed cause notice was served on him during the entire period of service. Initially, in terms of the notification letter of appointment, he was appointed on probation for 2 years. According to him, he had completed the probation period successfully, and there was no specific communication issued to him by the authority extending his probation. Thus, he was deemed to be confirmed as a judge. Then a subcommittee was made, Lordship, and they, of course, issued a notification eventually, which is para 3, discharging him. And Lordship, he then relied upon a notification in para 4, saying that he relied on that notification to say it's arbitrary, it is contrary to the rules and unsustainable in law, because he had put over 3 years, almost 4 years of service, Lordship. The High Court in para 5 dismissed his writ, Lordship. Next page, Lordship, para 6. Aggrieved by that, Lordship, the appellant has preferred the present appeal to this court under Article 136. The challenge to the judgment of the High Court, as well as the notification of 2000, is on the ground that the appellant could not have remained a probationer beyond the period of probation. So, Lordship, this is clear. This one is a case beyond. He held the office for more than 3 years. After this period, he would have been deemed to have been confirmed, and thus his discharge is contrary to the rules. Next page, Lordship, is the discharge order, which is para 8, Lordship. Para 9, clearly there's a finding that a bare reading of the above notification shows that it is ex facie, not stigmatic. It simply discharges the appellant from service as having been found unsuitable to hold the post of district judge until and unless the appellant is able to show circumstances supported by cogent material on record that this order is stigmatic and is intended to overreach the process of law. There is no occasion for this court to interfere. So even the bare reading of an order, Lordship, is not enough. There has to be cogent material, and they have to argue that. in terms of how it is stigmatic. As far as the law is concerned, the question raised is with regard to applicability of the concept of deemed confirmation to the present case under service jurisprudence. Next page, Lordship, was para 10 was on his conduct, Lordship. And basically, Lordships held that his affidavits also had contradictory stands. Page 46, Lordship. Para 25, Lordship. Which is on the purpose, in a sense, of probation, Lordship. The purpose of any probation is to ensure that before the employee attains the status of a confirmed regular employee, he should satisfactorily perform his duties and functions to enable the authorities to pass an appropriate order. In other words, the scheme of probation is to judge the ability, suitability, and performance of an officer under probation. Once these ingredients are satisfied, the authority may confirm this. Now, Lordship, in our case, respectfully, charges are framed out. And in our case, Lordship, the purpose of probation stands perfectly discharged and in our favor. Its objective is served. What else do you have a probation? In this period, there are other cases, Lordship, where the act is during the period of probation that we are dealing with. In this one, cogent materials show how the entry itself is tainted. And I would respectfully argue that what was the scheme of probation under the different rules, Lordship, stands fully served. Next page, Lordship. They look at the law in para 32 and we will read from 33, Lordship. So this one, Lordship, deals with the entire law up to that time.
Yes.
We have already noticed that two views are prevalent. Primarily, the court has taken the diametrically opposite view. One which accepts the application of deemed confirmation after the expiry of the prescribed period of probation, which in our case also doesn't apply because they are all within that period. While the other taking the view that it will not be appropriate to apply the concept of deemed confirmation to the officers on probation as it is not the intent of law. In our opinion, the rules and regulations governing a particular service are bound to have greater impact on determining such question. That is the precise reason we have discussed the rules in the earlier part. Next page. Which view out of the two views indicated above should be followed in the facts and circumstances of the present case can be fairly stated only after we have discussed the earlier judgments of the larger as well as equi-benches of this aspect. Let us at the outset refer to the Constitution bench of Dharam Singh. I read that, Lordship. In that case, the court was concerned with rule of Punjab, which fixed certain period beyond which the probation cannot be extended and an employee appointed or promoted to a post on probation is allowed to continue in that post after completion of the maximum period of probation. That view taken by the court was that there should be confirmation of the employee in the post by implication. So Dharam Singh is by implication beyond the maximum period. Then it, Lordship, refers to Dharam Singh, Lordship, in para 8 and in para 9, Lordship, around placentum F, just above placentum F is the rules did not require them to pass any test. Or, and that's what I'm relying on, to fulfill any other condition before confirmation. There was no compelling reason for dispensing with their services and re-employing them as temporary employees. Next sentence. In these circumstances, the High Court rightly held that the respondents must be deemed to have been confirmed in their posts. So that case was different. There was no requirement for such confirmation. In ours, there is. Lordship, para 36 is Shamsher Singh, Lordship. 7-judge Lordship. The 7-judge bench in Shamsher Singh versus State of Punjab was primarily concerned with the question whether termination during probation could be viewed as a punitive action in some cases or always has to be as a discharge simpliciter during the set period. The court expressed the view that no abstract proposition can be laid down, and where services of a probationer are terminated without saying anything more in the order of termination, it can never amount to punishment. In the facts and circumstances of the case, if the probationer is discharged on the ground of insufficiency or for similar reasons without a proper inquiry and without his getting a reasonable opportunity to show cause against the discharge, it may in a given case amount to removal from service within Article 3112 of the Constitution. But while dealing with this principal question, the bench even discussed at some length whether a probationer can be automatically be confirmed on the expiry of the period of probation. This court in Shamsher Singh considered the earlier judgment in Dharam Singh, discussing the case of the appellant who had completed his initial period of 2 years probation and the maximum period of 3 years probation. And by reason of the fact that he continued in service after the expiry of the maximum period of probation, he became confirmed, was the contention raised in the bench. Then para 38. The appellant in Shamsher Singh also had placed reliance on Dharam Singh to contend that the only view possible was that he would be deemed to have been confirmed. However, on the facts of the case before the bench, the court held as under, any confirmation by implication is negatived in the present case because before the completion of 3 years, the High Court found prima facie that the work as well as the conduct of the appellant was unsatisfactory. Next page, Lordship, para 72. In this context, reference may also be made to the proviso to the rule. The proviso to the rule states that the completion of the maximum period of 3 years probation would not confer on him the right to be confirmed till there is a permanent vacancy in the cadre. Rule 7 states that an express order of confirmation is necessary. The proviso to Rule 7.3 is in the negative form, that the completion of the maximum period of 3 years would not confirm a right of confirmation till there is a permanent vacancy in the cadre. The period of probation is therefore extended by implication until the proceedings commenced against a probationer like the appellant are concluded to enable the government to decide whether a probationer should be continued, confirmed, or his services should be terminated. No confirmation by implication can arise in the present case because of the meaning of the rules. Page 54, Lordship. This Lordship is another bench. They rely on the case of Karnataka versus Manjunath. And Lordship, in this also at placentum F, I'm reading the relevant part. Citation. No, this is within the judgment. It's all within the judgment. Para 42. That should not be considered to have satisfactorily completed the period of probation unless specific order to that effect is made, and the delay in issuance of a certificate would not entitle the person to be deemed to have satisfactorily completed the period of probation. Para 43, next page, Lordship. Did Lordship rely on Basim Beg and S. Manjunath and the sub-para 10, Lordship? Fourth sentence, one line of cases has held that if in the rule or order of appointment, a period of probation is specified and a power to extend probation is also confirmed. So, Lordship, in all of them, probation is mentioned. In police, it wasn't, but the power exists in the rule. And the officer is allowed to continue beyond the prescribed period of probation. He cannot be deemed to be confirmed, and there is no bar on the power of termination. No bar on the power of termination of the officer after the expiry of the initial or extended period of probation. This is because at the end of the probation, he becomes merely qualified or eligible for substantive permanent appointment. That is why the third factor is very important, the order of confirmation. The other line of cases, Lordship, are those where even though there is a provision in the rules for initial probation and extension thereof, a maximum period for such extension is also provided beyond, which is not permissible to extend probation. The Constitution bench dealt with that in Dharam Singh, Lordship. And then, Lordship, that's the Dharam Singh ratio. And para 11, Lordship, is building on Dharam Singh and Shamsher Singh. And I'll read the relevant part on the next page, Lordship. That I'll read from the last sentence, Lordship, on 55. Despite the indication of a maximum period of probation, the implied extension was held to render the maximum period of probation a directory one and not mandatory. Hence, it was held that a probationer in such cases, class of cases, is not to be considered confirmed till an order of confirmation is actually made. The further question for consideration in such category of cases where the maximum period of probation has been fixed would be as to whether there are anything else in the rules which had the effect of whittling down the right to deemed confirmation on account of the prescription of a maximum period of probation beyond which there is an embargo. So there also has to be an embargo. and upon further extension being made, and such stipulation was found wanting in the Dayaram Dayal's case. Next page, Lordship. Lordship, in para 44, they deal with the Madhya Pradesh versus Satyanarayan Chhavar. And then, Lordship, in its quoted paragraph 11. The question of deemed confirmation in service jurisprudence, which is dependent upon the language of the relevant service rules, has been the subject matter of consideration before this court times without number or in various decisions. And there have been 3 lines of cases on point. This para, Lordship, is very useful because it actually sums up what is the thinking on such cases. One line of cases is where in the service rules or in the letter of appointment, a period of probation is specified and power to extend the same is also conferred upon the authority without prescribing any maximum period of probation. And if the officer is continued beyond the prescribed or extended period, he cannot be deemed to have been confirmed. In such cases, there is no bar against termination at any point of time after expiry of the period of probation. This is the first line. Second line, Lordship. The other line of cases is that where there is a provision in the rules for initial probation and extension thereof, a maximum period of such extension is also provided, beyond which it is not permissible to extend probation. The inference in such cases is that the officer concerned is deemed to have been confirmed upon the expiry of the maximum period of probation, in case before its expiry, the order of termination has not been passed. The third line of cases is where, though under the rules, maximum period of probation is prescribed, but the same requires a specific act on the part of the employer by issuing an order of confirmation and of passing a test for the purpose of confirmation. In such cases, even if the maximum period of probation has expired and neither any order of confirmation has been passed, nor has the person concerned passed the requisite test, he cannot be deemed to have been confirmed merely because the said period expired. This applies to us. So, Lordship, respectfully, had we discharged them even after 4 years, being the maximum period in most of the service rules, barring police, had we not passed the order of confirmation, the right to terminate them would have existed. Of course, for us, happily, Lordship, it was done prior to 4 years. Page 60, Lordship, which is the final part of this judgment, Lordship. Para 46, Lordship, is basically saying you have to look at the pith and substance of the rules, Lordship. Para 47. There can be cases where the rules require a definite act on the part of the employer before an officer on probation can be confirmed. In other words, there may be a rule or regulation requiring the competent authority to examine the suitability of the probationer and then, upon recording its satisfaction, issue an order of confirmation. Where the rules are of this nature, the question of automatic confirmation would not even arise. Of course, every authority is expected to act properly and expeditiously, and then, Lordship, it speaks about that. So this is my case, Lordship. At 65 page, Lordship, is the next judgment. 2019, I'm giving you the SCC online. SC 1075. This is Durgabai Deshmukh Memorial School versus J.J. Vasu Sena. And this is by Lordship Chandrachud and Anirudh Post. So, Lordship, in this case, in para 1, it's mentioned in the last sentence that the division bench accepted the deemed confirmation. That was the issue, Lordship. And then, Lordship, it really is examining Rule 105 of the Delhi School Education Rules, para 2, Lordship, where the maximum period of probation permissible is 2 years. Then, Lordship, para 3 are the facts. And, Lordship, in para 5, the single judge held in favor. Para 6, Lordship, the division bench restored the order of the tribunal. And then, Lordship, they relied in para 7 on State of Punjab versus Dharam Singh. And finally, in para 8, the High Court concluded that the case of the respondent, first respondent, fell in the second category of cases enumerated in Madhya Pradesh versus Satyanarayan Jhavar, which I just read, Lordship. I'm not repeating all that. Page 68, Lordship. Now, page 68, Lordship, para 19 quotes the rule 105 of the 73 rule. And Lordship, it has an interesting language. That's why this matter went up there. Every employee shall on initial appointment be on probation for a period of 1 year, which may be extended by the appointing authority by another year. So Lordship, actually the interpretation required was, would by another year be only 1 more year, or by implication be another year after the end of the second year? That was the issue, Lordship. And then next page, Lordship, clause 2 was that if the work and conduct of an employee during the period of probation is found to be satisfactory, he shall, on the expiry of the period of probation or the extended period of probation, as the case may be, confirmed with effect from the date of expiry. So now that confirmation issue arises whether it is at the end of 2 years or beyond. And then, Lordship, it refers to in para 21, again, what we just read was the relevant paragraph 11 in the Satyanarayan Jhavar case, Lordship. So the contention before the court is in para 22. The High Court was of the view that the case of the first respondent fell in the second category of cases enumerated in Satyanarayan Jhavar, while the appellant contended that the case of the respondent falls in the first category. We, of course, pointed out we were in the third. Para 23. The points of law that arise for determination in the present appeal are whether the words by another year appearing in the principal part of the rule and in the first proviso limit the total duration of the permissible probation to 2 years, and whether the 73 rules require the issuance of an order of confirmation of the probation to be confirmed in service. Then, Lordship, in para 28, we are broadly talking about the purpose of probation, which is why I'm reading it. The words of a statute should be understood in the sense in which they are best harmonized with the subject of the enactment and the object with which the legislature has in view. The principle should be a useful guide in interpreting the provisions of delegated legislation, in this case, namely Rule 105. And then, Lordship, remark, the purpose of probation is to enable an assessment to be made of the performance of an employee. It serves as an opportunity for probationers to establish by the dint of their work, which is rendered during the period of probation, that they are suitable for being retained in service. On the part of the employer, probation enables the appointing authority to determine the suitability of the probationer for retention in service. Respectfully, Lordship, I am arguing that that's served in our case. Page 74, Lordship. So, para 44, 45, 46. 44 broadly says, Lordship, you cannot extend it beyond 2 years. That's the last part. Then it discusses Satyanarayan Jhavar, Lordship. And 46 says it does not lead to a deemed confirmation. I'm not reading it because we've settled the law, Lordship. I'm only pointing those paras. Para 47, Lordship. Lordships rely on G. Ramaswamy, the first judgment I read, Lordship. So that's good law, continuing. And then Lordship, para 48 deals with another judgment called Kedarnath Behel versus Punjab. And I'll read the quoted paragraph 9, Lordship. The law on the point is now settled, well settled. Where a person is appointed as a probationer in any post and a period of probation is specified, it does not follow that at the end of the said specified period of probation, he obtains confirmation automatically, even if no order is passed in that regard. Unless the terms of appointment clearly indicate that confirmation would be automatically follow effect, would automatically follow at the end of the specified period, or there is a specific service rule to that effect, the expiration of the probationary period does not necessarily lead to confirmation. At the end of the period of probation, an order confirming the officer is required to be passed. And if no such order is passed and he is not reverted to his substantive post, the result merely is that he continues in the post as probation. Then, Lordship, in the next para, it looks at other judgments. Para 50, Lordship, it refers to a recent judgment of Lawrence School, Lovedale, Lordship. And Lordship may only read in para 38 under that quoted the bold part. A confirmation as it demonstrable from the language employed in the rule does not occur with the efflux of time, as it is hedged by a condition. An affirmative or positive act is the requisite by the employer. In our considered view, an order of confirmation is required to be passed. The Lordship in all rules that is required. Para 51, Lordship, finally. It emerges from the consistent line of precedent of this court that where the relevant rule or the appointment letter stipulates a condition precedent to the confirmation of service, there is no deemed confirmation of service merely because the service of a probationer continued beyond the period of probation. It is only upon the issuance of an order of confirmation that the probationer is granted substantive appointment in the post. Then it talks about the rule, Lordship. Para 54, it relies on Dharam Singh, Lordship. Next page, Lordship. What I've already read, para 9 of Dharam Singh, Lordship, and finally para 55, Lordship. In Dharam Singh, the Constitution bench held that the continuation of the services of a probationer beyond the maximum period of probation would amount to a deemed confirmation of service only in the absence of a stipulation in the relevant rule. And then it talks of Rule 105 and again goes back to Satya Narayan Jhawar. So, Lordship, respectfully, our case is at a much higher pedestal. In all cases, the argument that I'm consistently holding, Lordship, and professing before Lordship, is that they were probationers who will be deemed to be probationers, irrespective, Lordship, whether we may have with Lordship's permission.
Yes.
I'm done. So, Lordship, no matter what I would have done as the state, I am covered by the rules 2+2. No matter what letter is issued by any department, increment, your not going to the battalion is reduced from 1 year to 4 months, it doesn't matter, you are a probationer. And you being a probationer will be deemed to continue in probation if I don't give you a positive letter of confirmation, which is not issued. So your status, or the petitioner's status in this case, Lordship, will remain to be temporary and subject to discharge if I feel that it is not satisfactory. I don't feel you are suitable to continue in service. That is the purpose of probation, Lordship. And in our case, at the very least, Lordship, if I can build that argument, is that I have cogent materials of an investigation. Now, the other line of cases is that the police report will commend itself to acceptance. That the police report may stand the scrutiny of a trial in a criminal proceeding is separate and certainly very separate to the writ jurisdiction of the court. They are two mutually exclusive. That appeal will follow its own track. Second, Lordship, if I go by an argument that at the first instance and brush, do I have enough reasonable material? And Lordship would have dealt with it, reasonable being, a reasonable man in that sense, looking at the material to form a prima facie view. And here, there is an investigation and enough material to form a prima facie view to the extent that in the criminal trial, a judicial mind is applied to frame the charges. That prima facie, the brush exists that yes, we must proceed with a trial. That they are accused, they deserve to be put to on trial. So, Lordship, our case is that the materials were cogent. Now, Lordship, there are judgments, and I will just come to it shortly. Acquittal will make no difference. In fact, there are judgments, Kishan Yadav is clear, acquittal ho gaya, so no problem, Lordship. That was your thing in a criminal trial. Your suitability under this is a separate issue. The next, Lordship, was the proposition, and that's at page 82, Lordship. Any order of simpliciter, discharge, or removal from service does not carry any stigma. And in such cases, the provision of Article 311 does not apply. The first case is a 1969 3 SCC 602 Union of India versus R.S. Dhaba. I read his name carefully. I had been reading it as Bhaba, but today I read it as Dhaba for the first time. So, Lordship, he, on page 83, para 2, joined the Income Tax Department as a UDC, Lordship. And then, Lordship, there are orders of promotion. And finally, on page 84, Lordship, he's reverted back in the middle of the page. He moved the High Court in the subsequent paragraph, Lordship, for grant of a writ to quash the order of reversion, Lordship. And then in para 3, Lordship, his arguments were put forth. And the argument of the state is that there were a number of complaints against him, Lordship. And it was on integrity in this case. Next page, Lordship, which is where I would like to start reading, Lordship. On the top of the page, Lordship 85. Referring to the reversion order of 64, there is nothing to show that a stigma was attached to the respondent. No reference is made to the imputation on the integrity of the respondent, and the only reason given in the respondent is that the respondent was found unsuitable to hold the post of income tax officer class 2. It is well established that a government service who is officiating in a post has no right to hold it for all time. And the government servant who is given an officiating post holds it on the implied term that he will have to be reverted if his work is found to be unsuitable. Pause, Lordship. The same implication is for a probation. That just because you are on probation, you are, and I have referred to Lordship judicial services. Probation is to be meant to be in that. You have to be found fit by the dint of your work and other factors. In a case of this description, or a reversion on the ground of unsuitability is an action in accordance with the terms of which the officiating of a post is held, and not a reduction in rank by way of punishment to which Article 311 of the Constitution could be attracted. It is, of course, well settled that a temporary government servants are also entitled to the protection of 3112 of the Constitution in the same manner as permanent government servants if the government takes action against them, meting out one of the three punishments, mainly dismissal, removal, or reduction in rank, which is Purushottam Lal Dhingra. I'll read that also later, Lordship. But this protection is only available where dismissal, removal, or reduction in rank is sought to be inflicted by way of punishment and not otherwise. As pointed out in Purushottam Lal Dhingra's case, the two tests available is in a matter of this description are: 1, whether the government servant has a right to the post or the rank. That's the first condition. 2, whether he has been visited with evil consequences, and if either of the two tests is satisfied, it must be held that the government servant had been punished. Further, even though misconduct, negligence, inefficiency, or other disqualification may be the motive or the inducing factor. So there's a distinction made, Lordship, which influences the government to take action under the express or implied terms of the contract of employment or under the statutory rules. Nevertheless, if a right exists under the contract or the rules to terminate the service, the motive operating on the mind of the government is wholly irrelevant. So that argument has come again and again, Lordship. Punishment, 311. If the right exists on part of the government, and if the person on whom there is an inducing factor material, that person has no right to the post, it's irrelevant, this argument. In our case, it applies squarely. The test for attracting Article 3112 of the Constitution is in such a case is whether the misconduct or negligence is a mere motive for the order of reversion or termination of service, or whether it is the very foundation of the order of termination of service of the temporary employee. And then it refers to an earlier decision. In the present case, however, the order of reversion does not contain any express words of stigma attributed to the conduct of the respondent, and therefore it cannot be held that the order of reversion was made by way of punishment, and the provisions of Article 311 of the Constitution are consequently attracted. And then it goes on to another view, Lordship. And on the next page, Lordship, paragraph 4, it says that the High Court erred in holding that the order of reversion was amounted to reduction in rank, Lordship. Page 93, Lordship. I must also, Lordship, point out
Yes.
that 311 primarily is at a much higher pedestal for government confirmed employees. Now, Lordship, I'm reading 1991 1 SCC 691, State of Uttar Pradesh versus Kaushal Kishore Shukla, on the rights of a person holding a post on temporary basis and the issue of motive foundation. I must say, Lordship, in fairness, the issue of motive foundation, all of this is a matter of continuous judicial attention, because it varies from a fact to fact, and then of course the ratio comes in that fact. So it's a continuing discourse, Lordship, no doubt about it. It starts at 96, Lordship. 97. The sole question which falls for consideration in this appeal is whether the order dated September 23rd, 1980, terminating the respondent's services, who was admittedly an ad hoc and temporary employee, is vitiated in law.
The High Court held that since juniors to the respondent were retained in service, while the respondent's services were terminated, the order of termination was discriminatory in nature. It further held that since the order of termination was founded on an adverse entry awarded to the respondent in his character role, without giving him an opportunity on the ground that was not suitable, the order cannot be said to be a decision given in good faith.
Paragraph 4, Lordship, basically says, long and short of the story is that Lordship, he was an assistant auditor.
Ms. Kohli, an employee in the nature of ad hoc and a regularly selected employee, the
Lordship.
appreciation would be different.
Of course, Lordship. And Lordship, I'm actually only going on the law. That's why the facts I only give as a matter of abundant.
Very well. Very well.
You're absolutely right. And Lordship, I can go straight. I was only saying in this case, there was corruption against it. We can go to para 7, Lordship, on page 19. That's why Lordship may note, I'm not even reading those paras.
Yes.
So Lordship, I'm starting from the middle of the page, Lordship. Placentum E. Under placentum E is under the service jurisprudence. It's towards the end of the page, just above 99, Lordship, page 99.
Yes.
And placentum E, just 2 sentences below, it starts under the service jurisprudence. And I'm reading the next paragraph. Under the service jurisprudence, a temporary employee has no right to hold the post and his services are liable to be terminated in accordance with the relevant service rules and the terms of contract of service. If on the perusal of the character role entries or on the basis of a preliminary inquiry on the allegations made against an employee, the competent authority is satisfied that the employee is not suitable for the service, whereupon the services of the temporary employee are terminated, no exception can be taken to such an order of termination. A temporary government servant has no rights to hold the post. His services are liable to be terminated by giving him a 1 month's notice without assigning any reason, either under the terms of contract providing for such termination or under the relevant statutory rules regulating the terms and conditions of a temporary government servant. A temporary government servant can, however, be dismissed from service by way of punishment. Wherever the competent authority is satisfied that the work and conduct of a temporary servant is not satisfactory, or his continuance in service is not in public interest on account of his unsuitability, misconduct, or inefficiency, it may either terminate the services in accordance with the terms and conditions of the service or the relevant rules, or it may decide to take punitive action against the temporary government servant. If it decides to take punitive action, it may hold a formal inquiry by framing charges and giving opportunity to the government servant in accordance with the provisions of Article 311 of the Constitution. Since a temporary government servant is also entitled to the protection of Article 3112 in the same manner as a permanent government servant, very often the question arises whether an order of termination is in accordance with the contract of service and relevant rules regulating the temporary employment or is in the way of a punishment. Then Lordship, it talks about Parshottam Lal Dhingra, and at placentum E, the sentence starts, it must be borne in mind, Lordship, that a temporary government servant has no right to hold the post, and termination of such a government servant does not visit him with any evil consequences. The evil consequences as held in Parshottam Lal Dhingra do not include the termination of services of a temporary government servant in accordance with the terms and conditions of service. The view taken by the Constitution bench in Dhingra have been reiterated and affirmed. And then it talks of the other case. Right. Now, Lordship, in our case, specifically 2 of them deal with the word temporary, taxation and transport, I beg your pardon. 8. The learned counsel for the respondent urged that the allegations made against the respondent in respect of the audit of Boys Fund of an educational institution were incorrect, and he was not given any opportunity of defense during the inquiry, which was held ex parte. Had he been given the opportunity, he would have placed correct facts before the inquiry officer. His services were terminated on allegation of misconduct founded on the basis of an ex parte inquiry report. So this is interesting, Lordship, this para. He further referred to the allegations made against the respondent in the counter affidavit filed before the High Court and urged that these facts demonstrate that the order of termination was in substance an order of termination founded on allegations of misconduct and ex parte inquiry report. In order to determine this question, it is necessary to consider the nature of the respondent's right to hold the post and to ascertain the nature and purpose of the inquiry held against him. As already observed, the respondent, being a temporary government servant, had no right to hold the post, and the competent authority terminated his services by an innocuous order of termination without casting any stigma on him. The termination order does not indict the respondent for any misconduct. The inquiry which was held against the respondent was preliminary in nature to ascertain the respondent's suitability and continuance in service. There was no element of punitive proceedings as no charges have been framed, no inquiry officer appointed, no findings were recorded. Instead, a preliminary inquiry was held, and on the report of the preliminary inquiry, the competent authority terminated the respondent's services by an innocuous order in accordance with the terms and conditions of the service. Mere fact that prior to the issue of the order of termination, an inquiry against the respondent in regard to the allegations of unauthorized audits of the Boys Fund was held does not change the nature of the order of termination into that of punishment, as after the preliminary inquiry, the competent authority took no steps to punish the respondent. Instead, it exercised its power to terminate the respondent's services in accordance with the contract of service and rules. Para 10 refers to Jagdish Mittal Lordship. Constitution bench of this court held that every order terminating the services of a temporary public servant does not amount to dismissal or removal from service merely because an inquiry was held before the order of termination was passed. The court observed that the appropriate authority has the power to terminate a temporary government, a public servant, either by discharging him under the terms of contract or the relevant rules, or by holding a departmental inquiry and dismissing him from service. So, Lordship, this is important because all three are. Before passing an order of termination, the competent authority may hold inquiry in fairness to ascertain whether the temporary employee should be continued in service or not. Now, in our case, Lordship, the police inquiry and the facts that emanate from it already met with that. To hold a second inquiry on the same facts, and there's the next one of the cases following very shortly will be the doctrine of empty formality. Considered. Next paragraph only quotes that, Lordship. The following paragraph, Lordship, is dealing with the Champaklal Chinmanlal case, Lordship, which is again broadly the same principle, Lordship. I'll go to the next page, Lordship. I'll start actually, Lordship, with your permission on 102 on the last sentence. So far as the preliminary inquiry is concerned, it's an interesting sentence, Lordship, that I marked. So far as the preliminary inquiry is concerned, there is no question of it being governed by Article 311(2) of the Constitution. And Lordship remark, it is made for the purpose of collection of to enable the competent authority to decide whether punitive action should be taken or action should be taken in terms and under the contract of service or the rules applicable to the government. So, Lordship, the purpose is also defined. It's only a collection of facts. It is not an opportunity for you to argue your case. A government servant has no right to insist for affording him an opportunity during such inquiry, and such an ex parte inquiry is not vitiated in law in view of the purpose and objective. So, Lordship, that argument also has been respectfully dealt with by Lordship's law. Then, Lordship, next, it continues on Purushottam Lal Dhingra, and Lordship continues to build on the same jurisprudence. Next page, last sentence, Lordship, on 104, Lordship, which, Lordship, is referring to para 11 is the A.G. Benjamin case. The last sentence, the court observed as under, next page, it is therefore the authority decides, if therefore the authority decides for some reason to drop the formal departmental inquiry, even though it had been initiated against the temporary government servant, it is still open to the authority to make an order of discharge simpliciter in terms of the contract of service or the relevant statutory rule. In such cases, the order of termination of services of the temporary government servant, which in form and substance is no more than his discharge effected under the terms of contract or the relevant rule, cannot in law be regarded as a dismissal because the appointing authority was actuated by the motive that the said government servant did not deserve to be continued in service for some alleged inefficiency or misconduct. We have referred to the above decision in detail to dispel any doubt about the correct position of law. It is erroneous to hold that where a preliminary inquiry into allegations against a temporary government servant is held, or where a disciplinary inquiry is held but dropped or abandoned before the issue of the order of termination, such order is necessarily punitive in nature. Now, Lordship, we have a case. The reason I read this, which was before the Honorable single judge, and the judgment has just been passed. In that case, He also was born in the same times, same service. He was, of course, an agricultural officer, but same exam, etc. And in his case, he somehow escaped the net. Despite being accused, the government escaped it. And an inquiry was, he came to the court raising Ajay Chaudhary Lordship and saying that you can't keep me suspended forever. And applying the ratio of Ajay Chaudhary Lordship, the departmental inquiry started on it. And then during that, we discharged. And that was the same. And then just 2 days ago, Lordship Suman Sham just passed the judgment. I'm sure it will eventually come up in appeal. But that also, I just was pointing out that that situation, which was one of its kind in our entire batch of cases, that also has been covered by the Honorable Supreme. Lordship, the last 2 paragraphs of page 106, Lordship, para 13. In the instance case, the respondent was a temporary government servant, and there was an adverse report regarding his work, which was reflected in the adverse remarks made for the year 1977. The competent authority held a preliminary inquiry in the allegations of improper conduct in carrying out unauthorized, etc., etc. On the result of the preliminary inquiry, no charges were framed against the respondent. No officer was appointed for holding the departmental inquiry. Instead, the competent authority chose to terminate the respondent's services in exercise of its powers under the terms of contract, as well as the relevant rules applicable to the temporary government servant. It never intended to dismiss the respondent from service. Holding a preliminary inquiry does not affect the nature of the termination order. The allegations made against the respondent contained in the counter affidavit, and this is very important, Lordship, because it's applicable to an argument made against us. The allegations made against the respondent contained in the counter affidavit by way of a defense filed on behalf of the appellants also do not change the nature and character of the order of the termination. Because this was argued, so this sentence became relevant. Lordship, at page 130. The Lordship, again and again, when our additional affidavit was assailed in during arguments, and then it was said the form and content changes. This also, Lordship, situation is not new, and that is our right to put it there. It does not make a difference to the order of discharge. 1995, 6 SCC 534, Hukum Chand Khundia versus Chandigarh Administration. Lordship, at 114. He was a clerk, Lordship, on probation, Lordship, temporary service. And he was terminated, Lordship. And then it's only a 1 paragraph judgment, Lordship. Para 2. Mr. P.P. Rao, the learned senior counsel appearing for the petitioner, has submitted that if termination has in fact been affected by way of punishment, the real purpose of the order and not the outer form of it is required to be looked into by piercing the veil. This is the identical argument, Lordship, that has also been professed. That you have to lift the veil, and the real purpose can be behind an innocuously worded order. The words used are innocuously worded discharge. He has submitted that on the score of misconduct, the service is terminated without holding a departmental proceeding and giving the petitioner a chance of showing cause. The order of ex parte termination of service on the ground of misconduct is illegal and void. This also has been argued, Lord. Even in the case of temporary service, the provisions of Article 311 of the Constitution is applicable. In support of such contention, reference has been made to the decision of this court in Jarnail Singh versus Punjab. It, however, appears to us that no discriminatory treatment has been meted out to the petitioner, as was done in the employee concerned in the said decision. It appears that the service of the petitioner was found unsatisfactory for the reasons indicated herein above. Since the petitioner was holding a temporary service and was on probation, an order of termination simpliciter has been passed without attaching any stigma against it. As the service records were found unsatisfactory, the termination order cannot be held arbitrary or capricious. In the aforesaid facts, we do not think that in reality an order of punishment has been passed against the petitioner in the cloak of pretense of termination simpliciter without holding any departmental proceeding, and thereby violating Article 311 of the Constitution, and therefore dismissed. The next judgment, Lordship, is next page itself. Again, a 2-para judgment, which is 1996, 5 SCC 89. A.V. Krishnamani versus Lalit Kala Academy. Again, Lordship, para 2 is that he was ad hoc Lordship, was put on probation, discharge, and then Lordship, para 4. It is contended by the appellant that since the averments made in the counter would constitution foundation for dismissal. And again, this judgment is relevant for the arguments that were made with regard to our counter. Would constitute foundation for dismissal for misconduct, an inquiry in this behalf was required to be made. On the other hand, it is contended by the respondent that during the probation, the appellant did not acquire any right to the post. If on being found suitable, he was regularized, only then he would have acquired the right to hold the post. During probation, it was found that his services were not satisfactory and reasons were given in support thereof. Thus, they do not constitute foundation, but motive to terminate the services. We find force in the contention of the respondent. They have explained that the driving of the staff car was not satisfactory and therefore they terminated the services of the appellant during probation. The very object of probation is to test the suitability, and if the appointing authority finds that the candidate is not suitable, it certainly has power to terminate the services of the employee. Under these circumstances, it cannot be held that the reasons mentioned constitute motive and not foundation. Next, Lordship, 2005, 1 SEC 132, Registrar of the High Court of Gujarat versus C.G. Sharma. At page 117, this was observations were made on the integrity of a judicial officer, Lordship. Lordship, our original argument remains that the entry itself is tainted. These are all cases of bona fide entry with no taint on the entry itself. So we are dealing with cases which I would say that required us to be at a higher pedestal, but we are still going to deal with the law. Lordship, on page 120 are the facts, Lordship. 2 appeals came up, Lordship. He was a civil judge on probation for a period of 2 years. And Lordship, he argued that he can't be terminated without an inquiry. Then Lordship, on page 121, para 5. They quote various judgments, Lordship. I'll take Lordship straight to, without getting into the facts, Lordship. Para page 126, Lordship. Para 26.
Yes.
A large number of authorities were cited before us by both the parties. However, it is not necessary to go into the details of all those cases for the simple reason that sub-rule 4 of rule 5 of the rules is pari materia with the rule which was considered in so-and-so judgment. And we find that even if the period of 2 years expires and the probationer is allowed to continue after a period of 2 years, automatic confirmation cannot be claimed as a matter of right, because in terms of the rules, work has to be satisfactory, which is a prerequisite or precondition for confirmation. And therefore, even if the probationer is allowed to continue beyond the period of 2 years, as mentioned in the rule, there is no question of deemed confirmation. The language in the rule itself excludes any chance of giving deemed or automatic confirmation, because the confirmation is to be ordered if there is a vacancy and if the work is found satisfactory. There is no question of confirmation, and therefore deemed confirmation in the light of the language of this rule is ruled out. We are therefore of the opinion that the argument advanced by the learned senior for the respondent on this aspect has no merits and no leg to stand. In the third last line of the same paragraph, we are therefore of the opinion that there is no question of automatic or deemed confirmation as contended by the learned senior for the respondent, and therefore answer this question in the negative against the respondent. Next page. Para 30.
Yes.
The argument of the learned senior counsel for the respondent that there is no finding on the fact either by the vigilance or by a unit judge that would cast any doubt regarding the integrity, and nothing has been placed on record by the authority before any of the courts to even remotely suggest that the respondent had indulged in any practice that would cast doubts about his integrity. Since the learned single judge and the learned judges of the division bench have not adverted to this fact, we, in order to see the record by ourselves and in order to shorten the litigation, summoned the original records and perused the same. And Lordship, the learned single judge called for every and looked at every file. We were asked to submit it. They were kept in the custody of the court. And this is without prejudice to the fact that we had already relied upon the police material and all that investigation material was available. But still, so there was a detailed exercise by this court also. We have closely perused the confidential register of the respondent, and it contains series of adverse entries, and it is abundantly clear that the respondent was not having good reputation as judicial officer, and his service was far from satisfactory. The district judges concerned, in view of his unsatisfactory performance and questionable integrity, have also recommended for the extension of probation. So, Lordship, integrity, not just in any public office, is one of the core expected values. Then comes efficiency and other things. 33. We have also perused the original correspondence in connection with the probation of the respondent. It is seen from the above records that the Vigilance Cell of the High Court had also investigated some matters regarding his integrity. These are all in a sense similar because we've had a police investigation. The district judge was of the opinion that though there would be no proof about integrity, but it is a fact that his integrity was doubtful. So in the absence of proof, we have a doubt about the integrity. That person can't be suitable to hold this post. And the representations made by the officer were also filed on many occasions. The representation made by the respondent in regard to the communication of adverse remarks was ordered to be filed before the Chief Justice and other portfolio judges. It is useful to reproduce the remarks by Mr. Justice R.K. Abhichandani while considering the note put up by the office on so and so. As per the office note, second part, not industrious, less diligent, below average, inadequate disposals, his conduct was suspicious. Lordship, even something as innocuous about the conduct being suspicious was enough to charge the judicial conscience of the court to say, no, we can't have such a person. And that too when the person is on probation, without a right. So then Lordship, para 36 deals with the decision.
These are all parameters of suitability.
Yes, Lordship, absolutely.
So they don't apply to the case at hand. You are not examining suitability in service period. These are all dealing with suitability in service.
But Lordship, respectfully, they would also be suitability for holding the post. So if you are not suitable to hold the post, you cannot be suitable in service.
Very well. That's it.
Lordship, para 37. This paragraph is important to one of the words I used in argument.
Yes.
Thus, it is seen that the respondent is not industrious, less diligent, below average, and inadequate disposal, and the conduct was suspicious and complete aloofness is lacking. And
these are both grounds for non-confirmation as well as for compulsory retirement, Mr. Kohli.
Lordship, the last sentence.
Yes.
In our opinion, such an officer should not be allowed to continue in service in public interest and in the interest of judicial administration. Both. It's the administration of the service and interest, public interest. That's the point I wanted to make. Next page, Lordship, in para 41, the argument of stigmatic order was dealt with, Lordship. Para 43, Lordship, on 131, talks about a termination order simpliciter and not being punitive, Lordship. And therefore, no opportunity needs to be given. And Lordship, para 47 again, building on the same thing what I just argued, Lordship.
Yes.
133. In our opinion, what is to be considered in such matters is the examination of overall entries of the officer concerned and not the entry here and there. It may well be in some cases that in spite of satisfactory performance, still the authority may decide to not extend the probation of an employee in public interest. As in the opinion of the said authority, the post has to be manned by a more efficient and dynamic person. There is no denying of the fact that in all organizations, there's a great deal of dead wood, and more so in government and judicial departments, which has to be replaced in public interest. That was the case, Lordship. In Lordship at 142, we need to go to 142. No, Lordship. We've dealt with the problem. I will respectfully, Lordship, just show one paragraph in this. 142 was in the High Court of, but Lordship, it's a, but I'll just read the last paragraph because there was a criminal case, Lordship. That's the only point I wanted to make. This is Shekhar Roy versus Union of India. And it's a division bench, Lordship. Civil rule, this is civil rule number 391 of 79. Para 14, Lordship, which is at 147. The learned counsel for the petitioner, however, submitted that a criminal case has been launched against the petitioner. Hence, the order was mala fide and arbitrary and was by way of punishment. No doubt the petitioner was prosecuted in a criminal court, and during the pendency of the trial, his services were terminated under the provisions of Rule 9 of the rule. It is open for the appointing authority to terminate the service of a temporary employee during the pendency of criminal proceeding, if the appointing authority is satisfied that the temporary employee is not suitable to hold the post. There is no rule, and then that's on the irrigation department. Prabhu.
Yes.
Lordship, next page, 148. Lordship, this is on the proposition that a writ will not be issued when it is not in public good. So it's on the invocation of the writ jurisdiction. State of Maharashtra versus Prabhu, 3-judge Lordship, 1994, 2 SCC 481. Lordship, 151. Detailed facts, Lordship. So, Lordship, the first paragraph. The question of law that arises for consideration in this appeal directed against the judgment and order of the Bombay High Court is if the High Court correctly construed so and so rule of the Maharashtra State Board of Secondary and Higher Education Act of 65, and even if it be so, then whether it was eminently fit and proper case for exercise of discretion under Article 226 of the Constitution. And then these facts are a little relevant. Basically, Lordship, he was put on the board and there were questions about it, of the Board of Education. That was the crux of it. It's very detailed, that paragraph. And it's basically saying that such a person, could he have been on the board when there were questions on it? The Lordship, on the next page, para 3, Lordship, below the quoted part is a bare perusal of the subsection, indicates that even though the power to remove a member of the board exists in the state government, but it can be exercised only if the government is of the opinion that the activities of the member are detrimental or obstructing the functioning of the board. The use of the word are is capable of giving rise to the construction that the activities which would empower the government to take action of removal of a member must arise out of his functioning as a member of the board. It can legitimately be urged, as was attempted by the learned counsel for the respondent, that it is activities in present which would give rise to an action under this subsection and not what happened in the past. This is what appears to have persuaded the High Court to take the view in favor of the respondent. But what was lost sight of was that the appointment of a member who does not carry an acceptable social image in society is ipso facto bad. A teacher who is expected to instill discipline in students and prepare them for future, found responsible for assisting or permitting copying in an examination, cannot be considered to be a proper person who would have been entrusted with the duties and responsibilities as are required to be discharged by the board. Induction of the respondent, who with his past records was undoubtedly ineligible to be appointed as a member, was detrimental to the board. It is not necessary to deal with this aspect further, as the order cannot be sustained for that reason. Even assuming that the construction placed before the High Court and vehemently defended by the learned counsel for the respondent is correct, should the High Court have interfered with the order of the government in exercise of its equity jurisdiction? The distinction between writs issued as a matter of right, such as habeas corpus, and those issued in exercise of discretion, such as certiorari and mandamus, are well known and explained in countless decisions given by this court and English courts. It is not necessary to recount them. The High Courts exercise control over government functioning and ensure obedience of rules and law by enforcing proper, fair, and just performance of duty. When the government or any authority passes an order which is contrary to the rules of or law, it becomes amenable to correction by the courts in exercise of their jurisdiction. But one of the principles inherent in this is that the exercise of power should be for the sake of justice. One of the yardsticks for it is that the quashing of the order results in greater harm to society than the court may restrain from exercising the power. On this test, the order of the High Court does not appear to be well-founded. Even assuming there was a technical breach and the show cause notice did not spell out that there were, even if there was a technical breach, Lordship, and the show cause notice did not spell out those relevant facts which could have empowered the government to take action, and Lordship remarked, the social injury by nominating or appointing the respondent to an office of responsibility must not only have raised the eyebrows in the educational circle, but is susceptible of creating unhealthy atmosphere. Then lordship at placetum E. Therefore, even if the order of the government was vitiated, either because it omitted to issue a proper show cause notice, or it could not have proceeded against the respondent for his past activities, the High Court should have refused to interfere in exercise of its equitable jurisdiction, as the facts of the case did not warrant interference. What could be more harmful to society than appointing the respondent as a member of the board?
Yes, yes.
Just one parallel.
Carry on, carry on.
Thank you, Lord.
Yes.
Board, a position of importance and responsibility, who was found responsible for mass copying at an examination center for which he was a supervisor. It shakes the confidence and faith of the society in the system and is prone to encouraging even the honest and sincere to deviate from their path. It is the responsibility of the High Court as custodian of the Constitution to maintain the social balance by interfering where necessary for the sake of justice and refusing to interfere where it is against the social interest and public.
Continue.
My lord, may I mention one matter?
Come back at two matters. Which of those two matters? Item number 40. 7017.
CEP matter, lordship.
No. Because that matter where this original record is there. That's most likely item number 50. Yes, item number 50. That original record is lying here since long. What is to be done of that?
So I can take, it can be given it to us. So whenever lordship requires.
Yes. That's what we'll do. इसमें order थोड़ा change करिए. लिखिएगा. This was mentioned or not? This has not been mentioned, we suppose.
My lord,
Who is appearing in item number 50, Mr. Malhotra? You are appearing?
I'm appearing for the private respondent, Your Worship.
And who is there for the appellate?
I'm for the petitioner, my lord.
Okay, so this matter is not likely to be taken up today.
Yes, my lord.
So when do you want?
My lord, another CEP method, they are also going to make a mention. They would like to have on 23rd,
My lord,
23rd November.
item
All right, so then
number
in the
I
meantime,
also there, can it be fixed on the same day together?
very well, we'll do that.
23rd November.
Yes. Land counsel for the petitioner prays that the matter may be this writ petition along with analogous writ petition number
Item number 70, my lord, WA
70.
70 WA 274 of
I
2020.
just tell you. No.
It's not an analogous matter.
No, that's
It's
not
a
an
different
analogous.
matter.
I
Okay.
tell your lordship what has happened. There is
Yeah.
item number 50
Hmm.
and item number 70.
Hmm.
I think my learned friend both are in common. 50 also 70.
Advocates are common.
Yeah, that's why
Okay.
he said that if it is not inconvenient. so it
That's
can be
okay.
fixed
That's
on
okay.
date Where he can.
Yes. Land counsel for the petition submits that the matter may be taken up in November. We find that bulky original record of the government is lying in the court file and thus the same is hereby returned to learned additional advocate general Mr. Kalita, who shall keep the same available on the next date of listing. We therefore direct that the record shall forthwith be returned to learned additional advocate general Mr. Kalita for keeping the same available on the next date. Denotify on 24th November. 23rd November. Likewise, in the item number 70, list on 23rd November as prayed by land counsel for the appellate.
Deeply obliged.
I'm obliged, Your Worship.
May please, your lordship. Lordship, I'm sorry to take the liberty at 2 o'clock, lordship. Lordship, there is an item number 68, your lordship. It's a tag matter 66 to 69.
Yes.
Lordship, the junior government advocate has taken adjournment, lordship, but we are not informed, your lordship. But we have no objection, lordship, as well be prepared. Lordship, in item number 68, lordship, there is an interim, lordship. that may be-
68,
Yes, lordship.
interim order shall continue.
Much obliged, lordship.
Yes. Yes, Mr. Kohli, please commence.
Lordship, at page 154 is the MC Mehta versus Union of India.
Hmm.
Starts at 156, Lordship, this is, you may note the citation, 1999, 6 SCC 237. 1999, 6 SCC 237. Lordship, basically this had to do with a petrol pump in the Delhi Ridge area, Lordship, which is a protected area. 159, Lordship. We can come to para 15, Lordship.
This citation is being prematurely cited, we would say. First, come to satisfy the court that admitted or indisputable factual position. One conclusion is possible. You have to address the court on that so far. So first address the court on that, then you may give
The
this.
judgment itself.
Yes, please. Not on the judgment, on the facts of the present case.
Yes, Lordship. Sorry, Lordship, I missed that. So if Lordship. if
So
I
you-
may
this
take
is
your
putting the
indulgence
cart before the horse.
Lordship.
You have not addressed the court on the unimpeachability of your material on the basis whereof
So
the
I'm
decision was
actually- So therefore, Lordship, what I'm doing is there are different legs of argument. I'm letting the judgment speak for it. Basically, Lordship, what is their case? This is what I started with, Lordship.
The judgment you given out separate copies. Here it talks. What are the SB judgment? Copy you had taken out the other day. Print out. No, this. So now you would be referring to the SB judgment, no? Single bench judgment.
Not yet, Lordship. Would you like me to?
Okay, very well. You
I'll go ahead.
continue.
I'll tell you how I was approaching this, Lordship. And then, of course, what.
No, as per your convenience.
Either way, Lordship,
You proceed as you are prepared, you proceed accordingly.
Yes, Lordship. Actually, if I may just on a lighter note, say if I remove the horse and put it as an engine, the train will still move in the same direction with my arguments, Lordship.
Very well.
So
Yes.
basically, Lordship, essentially, there are 5-6 things that they have, and I'll give an overview, Lordship, before I proceed further.
उस दिन print निकाला था ना आपने? You've taken out a separate print of the SB judgment. Where is that? Yes, please.
Lordship, what is the case? Our case is there's enough material. They are temporary. They were never confirmed during the period of their temporary or being on probation, which even if there is not a letter extending it, it is deemed to be on probation. They were discharged.
Yes.
Where does the material come from? The material comes from a police investigation.
Yes.
So therefore, 3-4 things flow from the other side when they challenge. The first, they say, they try to rely that there may be an issue with the argument of probation because there were increments or there were orders that came out in government postings that said we reduce the battalion, etc. So that argument, the judgments show that it doesn't matter. You are a probationer deemed to be on probation. The second line of argument is you can't rely on a police. And then the argument of acquittal is tied to that. The line of.
There was no argument based on acquittal.
It was argued earlier, Lordship. I'm mixing it, not in past before Lordship.
All right.
Because I've been at both cases, so Lordship will forgive me if I make an error once in a while. So Lordship, the argument is that you can't rely on a police.
On the police report, not
on the
police report which is relied upon in this case.
Which our argument per contra is that can be relied upon because, which of course at that time, senior advocate Mr. Chaudhary had argued it in great effect was when he was dealing with Kehlo to Joginder Pal. He was talking of the process of an inquiry conducted by the court, by the judges of the court.
Yes.
So there is some form of inquiry. So there should have been some form of inquiry. Now, our response to that, Lordship, is A, the next round of judgments after I finish this lot will show that you can rely on a dismissal on the basis of a police inquiry. In those cases, has been effected. It will apply to our case too. 1. 2, Lordship, a line of judgments that show that even a subsequent acquittal has no impact in terms of your dismissal. 3, the need for an inquiry. There are 2 legs that come to that, Lordship. A is the argument of principles of natural justice, which is what I'm now venturing into, Lordship. And B, the doctrine of empty formality. Either case, C, which I've just dealt with, Lordship, which has come out in the previous judgment, that the inquiry per se is only a collection of facts. There's no framing of charge, which were the line of judgments I just read. There is no inquiry officer. They're merely a collection of facts for me to decide suitability. Me means the government.
And what if the court finds that that so-called inquiry is tainted? Then what happens?
Lordship, we bow.
Okay, very well.
Because for that, Lordship, that is why this whole exercise. We are ultimately in Lordship's hand. I can only argue my case, and of course,
Yes.
finally, Lordship will. So I am now building those propositions through the judgments. And then at the end of it, Lordship, I come to the single judge's judgment. Of course, most of it has been read and Lordship has gone through, but I will just to run through it. So that's where I close. And then anything residual that Lordship requires me to answer, I would answer. There have been queries from the bench, and I would respond. There is also the argument of the approval, Lordship. That point had come up.
Not only that, there was one significant and substantial argument coming forth from Mr. Das, regarding your IO's conduct at that very stage. That will be something we would like to hear from you. How do you explain that?
And I will, Lordship. And on that also, my point to that is that, and just as a preliminary response to that right now.
Yes, yes.
And in the order of framing of charges, so I have 3 legs to that, Lordship.
That is a subsequent event. We would not like to go into that.
But Lordship, I have something important related to that in one sentence.
Yes.
One of the stands taken to deny the applicability of the Prevention of Corruption Act is we are not public servants.
That is post your decision. Yes, obviously. You are right in saying so.
Is that right? Absolutely, Lordship.
In a criminal trial, Mr. Kohli, the accused is entitled to take a defense of alibi as well as private defense. It's a settled law of Supreme Court.
And Lordship, therefore, our also argument to that is,
yes,
whatever are his arguments and remedies are available there, that cannot be brought in, interposed into the writ jurisdiction and on the judgment.
No doubt about that, yes.
So therefore, my argument is that that is a without prejudice argument that won't have an applicability to the judgment here, the facts here. He has all his rights for that in the proceeding in trial.
Yes.
Criminal. So, Lordship, may I return to
Yes, yes, please, carry on.
Lordship, at 159, Lordship, para 15, Lordship. It is true that whenever there is a clear violation of the principles of natural justice, the courts can be approached for a declaration that the order is void or setting aside the same. Here, the parties have approached this court because the orders of the department were consequential to the orders of this court. The question, however, is whether the court, in exercise of its discretion under Article 32 or 226, can refuse to exercise discretion on facts or the ground that no de facto prejudice is established. On the facts of this case, can this court not take into consideration the fact that any such declaration under so and so, this is Bharat Petroleum. Next paragraph, Lordship. Courts are not infrequently faced with a dilemma between breach of the rules of natural justice and the court's discretion to refuse relief, even though the rules of natural justice have been breached, on the ground that no real prejudice is caused to the affected party. 17. We shall initially refer to 2 cases where discretion was exercised not to grant relief, and the first one was a case where relief was refused, even though there was a breach of natural justice. This is the Gade Venkateshwara Rao versus Government of AP. This is 1960 judgment. Lordship, below placetum E, the sentence after Panchayat Samiti is, this court praised the said order of the government dated so and so to section 62 of the Act, and if there was so, notice to the Samiti was mandatory. 3 sentences down, Lordship. This order of the government was challenged unsuccessfully by the villagers in the High Court. On the appeal of the said villagers to this court, it was held that the latter order of the government dated 63 suffered from 2 defects. It was issued by the government without prior show cause notice to the villagers of Dharmaji Gudem, and the government had no power of review in respect of the government orders passed under section 62. But that there was other facts which this entitled the quashing order dated 63, even though it was passed in breach of the principles of natural justice. This court noticed that the setting aside of the order dated 63 would restore the earlier order of the government of 62, which was also passed without notice to the affected party, namely the Panchayat Samiti. Next page, Lordship. Placetum D. The above case is a clear authority for the proposition that it is not always necessary for the court to strike down an order merely because the order has been passed against the petitioner in breach of natural justice. The court can, under Article 32 or Article 226, refuse to exercise its discretion of striking down the order if such striking down will result in restoration of another order passed earlier in favor of the petitioner and against the opposite party in violation of principles of natural justice or is otherwise not in accordance with law. We would like next refer to another case where though there was no breach of principles of natural justice, this court held that the interference was not necessary if the result of interference would be the restoration of another order which would not be legal. That's the case of Mohammed Swaleh Lordship of 1988. Turn the page, para 20. It is true that in Writ versus Baldwin, it has been held that the breach of the principles of natural justice is in itself sufficient to grant relief and that no further de facto prejudice need to be shown. It is also true that the said principles have been followed by this court in several cases, but we might point out that this court has not laid down any absolute rule. This is clear from the judgment of Chinnappa Reddy Justice in S.L. Kapoor versus Judge Mohan. Principles of natural justice know of no exclusionary rule dependent on whether it would have made any difference if natural justice had been observed, and that non-observance of natural justice is itself prejudice to any man and proof of prejudice independently or proof of denial of natural justice is unnecessary. He also laid down an important qualification as follows. As we said earlier, where on the admitted or indisputable facts, only one conclusion is possible, and under the law, only one penalty is permissible, the court may not issue its writ to compel the observance of natural justice, not because it is not necessary to observe natural justice, but because courts do not issue futile writs. It is therefore clear that if on the admitted or undisputable factual position, only one conclusion is possible and permissible, the court need not issue a writ merely because there is a violation of principles of natural justice. Before we go into the final aspect of this contention, we would like to state that the cases relating to breach of natural justice do also occur where all facts are not admitted or are not all beyond dispute. In the context of those cases, there is a considerable case law and literature as to whether relief can be refused even if the court thinks that the case of the applicant is not one of real substance or that there is no substantial possibility of his success or that the result will not be different even if natural justice is followed. Last sentence. Reading of Ms. Stratton held that there must be demonstrable beyond doubt that the result would have been different. Lord Wolf in Lloyd versus Patel has also not disfavored refusal of discretion in certain cases of breach of natural justice. The New Zealand court in McCarthy versus Grant, however, goes halfway when it says that as in the case of bias, it is sufficient for the applicant to show there is real likelihood, not certainty of prejudice. On the other hand, Ghana administrative law says that the slight proof that the result would have been different is sufficient. On the other side of the argument, we have, apart from Ridge and Baldwin, in John versus Rees, stating that there are always open and shut cases and no absolute rule of proof of prejudice can be laid down. Merits are not for the court, but for the authority to consider. Then at E, Wade administrative law says that while futile writs may not be issued, a distinction has to be made according to the nature of the decision. Thus, in relation to cases other than those relating to admitted or indisputable facts, there is considerable divergence of opinion whether the applicant can be compelled to prove that the outcome will be in his favor, or he has to prove a case of substance, or he can prove a real likelihood of success, or he can be entitled to relief even if there is some remote chance of success. We may, however, point out that even in cases where the facts are not all admitted or beyond dispute, there is a considerable unanimity that the courts can, in exercise of their discretion, refuse certiorari, prohibition, mandamus, or injunction, even though natural justice is not followed. Next page, Lordship, paragraph 3. We do not propose to express any opinion on the correctness or otherwise of the useless formality theory and leave the matter for decision in an appropriate case, inasmuch as the case before us, admitted and indisputable, shows that the grant of a writ will be in vain, as pointed out by Justice Chinnappa. Now what? I will, Lordship, refer to Parshottam Lal Dhingra and Shamsher Singh 3-4 paragraphs. Lordship, do you have a copy of them? May I give the citation?
You can give a citation, we don't have any problem.
Lordship. These are other judgments, Lordship. The citation of Parshottam Lal Dhingra is 1958 SCR 828 or AIR 1958 SC 36.
Anyway, if you could have given the list in advance, they would have taken it.
My colleague. We can refer it later. Not, we can go to the next.
No, no, he'll take it out in a moment.
You take it out, we'll give them this, we'll come back to it because they are general principles. The Lordship, I'm giving the second compilation. Its part 1 is written on it, Lordship.
Yes.
I'm reading it later. Lordship, right on the top, we have mentioned the issue is where the appointment has been secured through illegal means. The appointment is per se illegal at the threshold itself and deserves to be set aside. If the tainted and untainted appointments can be separately identified, action taken by the state to discharge such persons whose appointment are tainted in nature would be in conformity with law. And Krishan Yadav is the first judgment on page 1, Lordship. This has also been, these are all relied upon in this data.
Yes.
At page 3 are the facts, Lordship. Both these cases can be dealt under a common judgment, since what arises for our consideration is the validity of the selection of taxation inspectors by the subordinate selection board. The appellants are the unsuccessful candidates. So para 4, Lordship, 5, 6, 7, 8. Basically, Lordship talks about written examinations, fictitious roll numbers were given, Lordship, to each candidate. There was a question of rechecking, Lordship. Interviews were directed to be taking place at a very short notice, Lordship. And in para 8, it refers to Respondent 4, who was the chairman of the board, who resigned. There was no medical examination. And basically 9 is, for reasons best known, the original records, including answer books, were destroyed.
This was a case wherein the entire recruitment was scrubbed. They don't dispute that theory.
No, Lordship.
They
But
don't
what
dispute
you
that
point
theory.
to will be on the police inquiry. I'm on the police.
Yes, very good.
That's why I'm not getting into this. So, Lordship, para 11 is where I start reading 12. In view of the serious allegations made, particularly the destruction of records alleged to be for want of space, this court passed orders in 1991 directing the government of Haryana to refer the matter to the CBI for investigation and to complete the investigation within 3 months. The time for completing was extended. The police superintendent of police files a detailed report. We record the same.
Mr. Kohli, here you wait. The Supreme Court says we record the report. So there was an imprimatur to the report of the CBI. And would you even delve into that space that you are placing the investigation by the local police and the CBI on the same pedestal?
No, Lord. My proposition is set.
Yes, okay.
My proposition is
Yes.
that the reliance of the report was sufficient.
Report by whom? Question here is.
In
That's
this
a different
case,
report made pursuant to direction of the court and approved by the court. That'll you, how can you place the two things on the same pedestal?
Because, Lordship, I'm not, in that sense, arguing against the proposition that Lordship is saying. I'm merely pointing out that what flowed in both our case and in the case of.
So had it been a case wherein you took a decision to scrap the entire selection based on the police report, nobody would have any issue about that. As you said, there was a PIL file for this very purpose. So that's not the situation in the case at hand.
Right, Lordship. So I'll take you then further.
Herein you have tried to separate people on basis of a police report which was not tested at any judicial level. That is what the proposition is.
Which is what they have also been arguing in
Yes,
terms
they
of
have been
Joginder Pal. But in the Lordship in Joginder Pal, finally, in para 19, which is what I'll just reiterate later.
Yes.
Finally, it says there is no problem with the tainted. Which is what our case is. Our case essentially is a very small class of people who are tainted in terms of the entry on sufficient evidence with regard to them being.
Further argument which is coming forth is that if you had identified and taken action against all tainted as per your own police record, they won't have any problem. If you are selective in picking out the tainted, whether your exercise of separating the chaff from the grain can be said to be fair.
So, Lordship,
yes,
be related. And I'll answer that right now.
Yeah, very well.
That would be related. The argument being made is mixing another class of persons with them. So if I may say now, there are 3 or 4 classes of people that we deal.
Yes.
There are the untainted. There are those who are before Lordship who are tainted on the following factors. And let's now look at the factors. A, even if I say that the admission on a 161 is not admissible in that, but what does the evidence of the investigation? That their answer sheets were replaced. Their answer sheets were duplicate. They were rewritten by the same people and put in the strong room.
Right.
These petitioners are that class. So let's now first segregate them, Lordship. Because ultimately equals have to be treated equally.
Yes.
Unequals can't be treated equally. Now let's go to the second law.
Yes.
It was an ongoing investigation.
Yes.
We took action against these because let us say in our estimate, these people or these identified beneficiaries are
Only we'll put you a straight query.
Lordship.
There were 9 people regarding whom there was a report with the IO before this action took place. He kept that report under covers. What is the sanctity of your IO's actions? Tell us straight up.
I'm just building the big picture and I'll answer that also tomorrow. First point, Lordship, I said these are the identified people. I have to establish that the identically placed people have been treated differently.
Yes.
But if I can establish they are not identical, then my treatment being different would be a separate issue. There will be a separate cause of action. It can be treated separately.
Yes.
Where I am, Lordship, is very simply that every one of these have rewritten their exam. And I'm saying it, Lordship, or instructions, there is no case of someone else having rewritten the exam, putting it back into the strong room, having an invigilator's signature being put there is a beneficiary of any action of the state. Now there are.
What about your 3 approvers?
I'm coming. I was coming to that because that's the logical next corollary. There are 3 approvers. On that, Lordship, the power to grant a discharge and make them an approver is by the court.
For the purpose of a criminal trial.
Yes, Lordship. For the purpose of a criminal trial. But Lordship, interestingly, the courts, and I have judgments which I'll show later on this, that Article 14 can't be brought in a situation of an approval. A clear judgment on that, Lordship.
In a situation of?
That you compare the approver with the accused of the same.
Not in a criminal trial. Not in a criminal trial. We are on these proceedings.
In a criminal trial, Lordship, it would be separate. Article 14 wouldn't apply in the criminal trial. It's a different. I'm talking of the writ jurisdiction, Lordship.
Yes.
In a criminal trial, Lordship, the approver becomes a witness. He sits in the witness box. He's not the accused. He has been discharged in the case. The concept of the approver is that unless the approver goes against that commitment of coming out with the truth and nothing but the truth,
and
that can be reversed. There is no such situation. Currently, Lordship, the attack on the approver is because of the criminal trial. Now let's come to the writ jurisdiction, Lordship.
Yes.
And there's a judgment of Madras High Court, which we had looked at also, which directly deals with the Article 14 argument. That Article 14 won't apply to an approver with an accused. So, Lordship, these are arguments respectfully. In my humble submission is to find whether we can get something to impact the trial, because the trial is at a higher pedestal of beyond reasonable doubt.
Yes.
So therefore, these arguments by the learned counsel would be more in that nature. I don't treat them as equally, in my humble submission, Lordship, as he is entitled to his submission, is that they are identically placed. Because I will then say, show me another case from the identified beneficiaries who have been discharged, who have also written the question paper, replaced the answer sheet, got the invigilator signature, gone through a forensic, and then come out. This is a case of people at a lower pedestal. Now let's come to the lower pedestal, which is the other leg of the argument. What happened of them? Now, simultaneously, an outcome of the PIL was the BK Sarma Commission of Inquiry, Lordship. On the BK Sarma Commission of Inquiry, that report came. That report, and the law on the Commission of Inquiry is very clear. It is recommendatory. It cannot be a direction in that sense. It is for the government to consider. I won't get into what it is, but I can satisfy Lordship later if Lordship wants to know details.
We are not called upon to decide the niceties of the report.
Now, Lordship, on that
not go into that.
A committee was formed
Yes.
of the government. I happen to be a member of the committee, so I'm aware. And on that committee, some things are being examined further, etc. Now, with regard to the other members of the civil service, our committee finding so far is, and it's not concluded, so I can only say up to now, is we haven't found a case that we have been discriminatory to these 39 by protecting anyone who was identified.
Okay.
So that's where we are. Yeah, proceed.
Carry on.
I hope I was not too aggressive, Lordship. In my
No, not an issue at all. Being assertive and aggressive are two different propositions. Yes. And yes, lawyer has a right to be aggressive sometimes.
No, but
There's no
that's
difficulty.
why I said, Lordship.
It should not be offensive.
That's what I was hoping. I did not inadvertently.
No.
Because I don't do it advertently in any case.
No.
So, Lordship, let us come to 16 onwards. That's where my case, really my argument is.
16.
Which is page 10, Lordship.
Oh.
May I read, Lordship?
Yes.
Having regard to all of the above, the irresistible conclusion is fraud has reached its crescendo. Deeds as foul as these are inconceivable, much less could be perpetrated. Then it reminds Shakespeare, Lordship, 17. It may not be too much to draw an inference. Lordship, we need to know. It's an inference based on a report that all these were motivated by extraneous considerations. This is not a detailed inquiry, Lordship. It's an inference. We are at that threshold. Otherwise, how does one account for selection without interview, fake and ghost interviews, tampering with the final records, fabricating documents, forgery? Each of this would attract the penal consequences in the Indian Penal Code. They have been done with impunity. The story does not end here. From out of the selection list, secret communications have been sent to candidates. Selections have been made without medical test or verification of antecedents. It is highly regrettable that the holders of public offices, both big and small, have forgotten that the offices entrusted to them are sacred trusts. Such offices are meant for use and not abuse. From a minister to a menial, everyone has been dishonest to gain undue advantage. The whole examination and the interview has turned out to be a farcical, exhibiting base character of those who have been responsible for this sordid episode. It shocks our conscience to come across such a systemic fraud. It is somewhat surprising that the High Court should have taken the path of least resistance, stating in view of the destruction of records that it was helpless. It should have helped itself. Law is not that powerless. All on an inference of a report. In the above circumstances, what do we do? The only proper course open to us is to set aside the entire selection. The plea was made that the innocent candidates should not be penalized for the misdeeds of others. We are unable to accept this argument. When the entire selection is stinking, conceived in fraud and delivered in deceit, individual innocence has no place as fraud unravels everything. To put it in other words, the entire selection is arbitrary. It is that which is faulted and not the individual candidates. Accordingly, we set aside the taxation inspector's selection. Para 21 logic. The effect of setting aside the selection would mean the appointments held by these 96 candidates, including the respondents, will have no right to go to the office. Now, Lordship may mark. Normally speaking, we should require them to disgorge the benefit of these ill-gotten gains. That means if you have received salary, and in our cases, you are void, you're tainted, you have benefited from public money. That right exists, but they say that means they will have to repay the entire salary and perks which they have received from the said office. But here we show a streak of sympathy, not a right. For more than 4 years, they were enjoying the benefit of office. The proper lesson would be learned by them if their appointments are set aside, teaching them that dishonesty would never pay. And then in the end, Lordship, they also give 10,000 to some of the candidates who have suffered a lot. So broadly, I wanted to rely on these paras, Lordship. Page 14, Lordship, is the state of Madhya Pradesh versus Shama Parthi, 1996, 7 SCC 118. Lordship, this was the case. Again, on principle, the natural justice, very short judgment was. So this was the cancellation of appointments in
Unqualified candidates were selected. Unqualified candidates were selected.
Yes, Lordship. Para 4, Lordship. The
Yes.
tribunal in the impugned order has held that the respondents have been selected and undergone the training and competent authority having duly appointed them. Cancellation of their appointment without any opportunity is violative of principles of natural justice, and it accordingly set aside the order and directed their reinstatement with consequential benefit. Hence the appeal. It is
Mr.
now-
Kohli, Alka Oja is the judgment wherein the motor transport inspectors had served for 5 years, and they're merely on the ground that they did not possess that license, they were sent home. So that is well settled principle.
And Lordship,
No.
one judgment which I'll bring later is R. Vishwanath Pillai after 27 years. IPS on a false caste certificate. We found Hem Singh. I don't know if Lordship was referring to that as the Rajasthan judge.
Must be Hem Singh, yes.
Because Hem Singh is also 17. He was acquitted.
Hem Singh, yes. That was the judgment.
Yes, because you had mentioned Rajasthan. So that's what I suspect.
Hem Singh is the judgment, yes.
The Lordship next is O. Chakradhar on page
Yes.
16, Lordship. They were Lordship on page 18 is basic facts. They were basically clerks, junior clerks come typists. After 3 years of appointment, they were Lordship, basically not subjected to a typewriting test and they were removed.
The entire selection was set aside in that also.
Entire panel, just Lordship to decide which is on the next page on 19.
Herein, the situation is not
Yes, Lordship.
on the same footing.
So
We
Lordship, actually, what we are doing is, I must point out, Lordship, I am not relying on the facts qua the selection process or its cancellation. I am relying on the facts qua somewhere.
the reliability of the police report you are referring to, that we understand.
That's my case.
But again, each of these cases refers to a CBI report, Mr. Kohli. Therein again, there is a distinction.
Well, Lordship, I would say respectfully. Lordship.
The writ jurisdiction is invoked right, left and center for prayer to send the investigation to CBI. So there must be some greater sanctity to the proceedings of that agency.
Lordship, I must say, I was going to say something different actually. I was going to say respectfully, Lordship, the poor CBI, and I use the word poor CBI, ranges from a caged planet to the stalwart of independence in terms of its case. And I respectfully stand, Lordship, for the fact that ultimately we have to repose faith on our own police. Unless
That is
there's no
right.
reason
That is right.
not to have done their duty in a bona fide. Because ultimately the state.
Or unless the selections have been made in this manner. Tell us
I am obliged to-
what about the investigations which these people did for 3 years, 4 years, they were in service? Can you reverse that process?
Well, Lordship, I have only come to see with series of judgments that actually law, when we come before Lordship, it's not powerless. I think the judgments that eloquently are able to mold it in the circumstances. That's why
That's
we
right,
go to the
that's
principle. It's in the facts of the case.
Very well.
And will not act as a precedent. That's the other line, Lordship, that comes from
Yes.
specific fact. So, Lordship, in precedent D on page 19,
Yes.
one of the arguments was it was further been observed that the report of the CBI cannot be the only refuge for cancellation of this. This was the argument which I wanted to.
Yes.
But its content should have been brought to the knowledge of the applicant in a concise form to enable him to give a proper reply. But it was not done by the administration. Thus, in the absence of proper notice and opportunity to the candidate, the order of termination of the applicant stands vitiated. The tribunal also observed that the CBI report was not placed before it. With the above findings, it was set aside. Para 5, the writ preferred by the appellant against the order of the tribunal was dismissed as indicated earlier. The judgment of the High Court in the writ petition is also based mainly on the ground of violation of principles of natural justice and that no notice was given to the candidates, was vague and amounted to no notice. Para 6 is what the union argued. They argue on Krishna Yadav, which I just read. And then goes on to say, on the basis of the same, it has vehemently been urged that in a case where irregularity committed in the process of selection is all pervasive, initiating the whole selection, in that event, it would not be required that each selectee would be served with an individual show cause notice. In such circumstances, it will be open to cancel the whole selection. Mr. P.S. Mishra, learned senior counsel, appearing for the respondent, has however urged that it was necessary to make known to the respondent appointee about the exact and precise nature of the irregularity committed, as well as the misconduct, if any, attributable to him, so that it could be possible for him to have explained the position which has otherwise adversely affected the respondent. It was further submitted that the order of termination is in clear violation of 311. Para 7. Before we proceed, it would be appropriate to peruse and the decisions relying on parties. In the case of Krishan Yadav, the allegations of favoritism and arbitrariness in holding the selection for the post was made out. Then Lordship below classification E. In such circumstances, it was held, the entire selection was vitiated, even in respect of those who had already been appointed and had been working for a past few years. It was further observed that individual case of innocence will have no relevance in the circumstances. Then Lordship, para 8, next page. In our view, the nature and the extent of illegalities and irregularities committed in conducting a selection will have to be scrutinized in each case so as to come to the conclusion about future course of action to be adopted in the matter. if the mischief played is so widespread and all pervasive, affecting the result, so as to make it difficult to pick out the persons who have been unlawfully benefited or wrongly deprived of the selection. In such case, it will be neither possible nor necessary to issue individual show cause notices. The only way out would be cancel. In para 9, last sentence. To find out the position in the present case, we have to scrutinize the report. So basically, the court is merely looking at that. Lordship, para.
Court has made an exhaustive consideration of the report.
Yes,
It's not a superficial reference.
No, Your Lordship.
Minute facts have been
Lordship.
considered.
Yes, Lordship. Now, Lordship, if I may read para 12, the last para. As per the report of the CBI, the whole selection smacks of malafides and arbitration. All norms are said to have been violated with impunity at each stage, right from the stage of entertaining applications with answer sheets while in the custody of the chairperson. This is similar. In holding, etc. Just above placetum D, the illegality and irregularity are so intermixed with the whole process of selection that it becomes impossible to sort out the right from the wrong or vice versa. The result of such a selection cannot be decided upon or acted upon. It is not a case where a question of misconduct on the part of candidate is to be gone into, but a case where those who conducted the selection have rendered it wholly unacceptable. Guilt of those who have been selected is not the question under consideration, but the question is, could such a selection be acted upon in public employment? And then, Lordship, they set it aside.
The entire selection was in that.
So the point I'm making, in both these cases is not the setting aside of the selection process or the examination. It is the reliance on a report. That means now there are two arguments. Their argument is that the court examined the report. My argument is that the learned single judge examined it because all things were brought before the learned single judge. That exercise can be done, and we are in lordship time. Each case file was perused. Everything was brought. It is only after due consideration of that finally the learned single judge writes the impugned judgment. There has not been looking into the materials at hand. They are now, the argument that has been professed is that these cases are CBI, this is a state police. Respectfully, my answer remains that there is a report by an investigative agency that is credible to do the investigation. Next, Lordship, the third argument comes that nevertheless, in Kehlo and others series, there was the court-appointed inquiry. Our argument to it that there has to be an inquiry by someone before you say that he's unsuitable. Now, let me take another thing, Lordship. The judgments that I just relied upon earlier on judicial officers, in those cases, there were no police reports.
They were the supervisory reports of that is the only material for judging the suitability of the candidate.
Right, Lordship?
That is what the relevant material is.
After upon a fide entry, but suspicion. One of the cases was merely suspicion.
Confirmation in service on ground of non-suitability or non-confirmation. That is settled law, service law. That material which was relied upon, as a matter of fact, those judgments had no relevance to the present fact. Very well. Yes.
Then Lordship, next page 24.
Yes, please.
Ashok Kumar Sonkar versus Union of India, 2007, 4 SEC 54. On page 28, Lordship. This had to do, Lordship, with
eligibility on the last date, as on last date of submission of the application forms.
right, Lordship. Lordship has gone through everything.
Ashok Sonkar is cited every other day, sir, on this principle. That's what Alka Oja lays down. Therein the candidates who are working for 5 years, they were sent home.
Lordship 36, para 26.
Yes.
This brings us to the question as to whether the principles of natural justice were required to be complied with. There cannot be any doubt whatsoever that the ode alteram partem is one of the basic pillars of natural justice, which no one should be condemned unheard. However, wherever possible, the principle of natural justice should be followed. Ordinarily, in a case of this nature, the same should have been complied with. Para 27. It is also, however, well settled that it cannot be put any straight jacket formula. It may not be applied in a given case unless a prejudice is shown. It is not necessary that where it would be a futile exercise. A court of law does not insist on compliance with useless formality. It will not issue any such direction where the result would remain the same. in view of the fact situation prevailing or in terms of the legal consequences. Furthermore, in this case, the selection of the appellant was illegal, he was not qualified, etc. Next page, Lordship, para 29 deals with another judgment on useless formality, which is the Aligarh Muslim University. Next, para 30, Lordship, is Karnataka SRTC. I'll read that. The question as to what extent principles of natural justice are required to be complied with would depend upon the fact situation obtaining in each case. The principles of natural justice cannot be applied in vacuum. They cannot be put in a straitjacket formula. The principles of natural justice are furthermore not required to be complied with when it will lead to an empty formality. What is needed for the employer in a case of this nature is to apply the objective criteria for arriving at subjective satisfaction. If the criteria required for arriving at an objective satisfaction stands fulfilled, the principles of natural justice may not be complied with a view, and that's the rest. Next page, Lordship. Para Placetum DE, Lordship. It's again talking the principles of equity in a case of this nature, in our opinion, will have no role. Sympathy, as is well known, should not be misplaced. Lordship, this is also in response to one argument that where will they go now after this? Last paragraph, page 40, Lordship, 34. It is not a case where the appointment was irregular. If an appointment is irregular, the same can be regularized. The court may not take serious note of an irregularity within the meaning of the provisions of the Act. But if an appointment is illegal, it is non-est in the eyes of law, which renders the appointment to be a null. This was the main sentence I was relying. Lordship, there's another compilation. It says part 2, Lordship. Just share a copy. These are all in response to the various things argued, Lordship. What was argued in terms of 311 Article 311 Section. Lordship, this one is the first 4 judgments. In Tulsiram Patel, it's a very detailed judgment, but I'm referring to 4-5 paras. So it basically talks about the withdrawal of protection is a matter of public policy. This is 1985, 3 SCC, 390. 5 Judge, Tulsiram Patel. Lordship, we'll go to para 44, which is on. This is page 45, Lordship.
Yes.
Ministers frame policies and legislatures enact laws and lay down the mode in which such policies are to be carried out and the object of the legislation achieved. In many cases in a welfare state such as ours, such policies and statutes are intended to bring about socio-economic reforms and the uplift of the poor and disadvantaged classes. From the nature of things, the task of efficiently and effectively implementing these policies and enactments, and Lordship may mark, however, rests with the civil service. The public is therefore vitally interested in the efficiency and integrity of such services. Government servants are, after all, paid from the public exchequer, to which everyone contributes either way of direct or indirect taxes. Those who are paid by the public and are charged with public administration for public good must therefore in their turn bring to the discharge of their duties a sense of responsibility. The efficiency of public administration does not depend only upon the top echelons of the services. It depends much upon all the members of such services, even on those in the most subordinate post. For instance, railways do not run because of the members of the railway board or the general managers of different railways or the heads of the department. Then 4 sentences from below. But for a government servant to discharge his duties faithfully and conscientiously, he must have a feeling of security of tenure under the Constitution. This is provided for by the acts and the rules made under Article 309, as also by the safeguards in respect of the punishments of dismissal, removal, or reduction in the rank provided in clauses 1 and 2. I'm pausing for a minute. What essentially, Lordship, and it's very evident, is that if you have an officer, you protect an officer. But obviously, these are meant for protection of those who have made a bona fide entry, and if there is a misconduct, you're in discharge of the official. So the protections meant for, which is our argument, for the bona fide entry of an officer cannot be used for one with a tainted end. That's our argument. So we are only showing what courts have had. Next, Lordship, on page 46. It is, however, as much in public interest and for the public good that government servants who are inefficient, dishonest, or corrupt, or have become a security risk should not continue in service, and that the protection accorded to them by the acts and rules made under Article 309 and by Article 311 be not abused by them to the detriment of public interest and public good. Then 3 sentences below, Lordship. The livelihood of an individual is a matter of great concern to him and his family, but his livelihood is a matter of private interest. And where such livelihood is provided by the public exchequer and the taking away of such livelihood is in the public interest and for the public good, the former must yield to the latter. These consequences follow not because of the pleasure doctrine is a special prerogative of the British Crown, which has been inherited by India and transposed into our constitution, adapted to suit the constitutional setup of our republic, but because public policy requires, public interest needs, and public good demands that there should be such a doctrine. Para 101, Lordship, is at page 82. I'm making good the words I used, Lordship, in my opening arguments. Very Lordship.
Yes.
Not only therefore can the principles of natural justice be modified, but in exceptional cases, they can even be excluded. There are well-defined exceptions to the nemo judex in causa sua rule, as also to audi alteram partem rule. The nemo judex in causa sua rule is subject to the doctrine of necessity and yields to it, as pointed out by this court in Mahapatra versus Odisha. So far as the audi alteram partem rule is concerned, both in England and in India, it is well established that where a right to a prior notice and an opportunity to be heard before an order is passed would obstruct the taking of prompt action, such a right can be excluded. 103, Lordship, para 125.
Yes.
Some of the orders impugned before us refer only to one or the other of the 3 clauses of the second proviso to Article 311(2), or dispensing with an inquiry without referring to the relevant service rule. Some refer both to a clause of the second proviso and the relevant service rule, while the others refer only to the relevant service rule without making any mention of the particular clause of the second proviso which has been applied. The question is whether the omission to mention the particular clause of the second proviso or the relevant service rule makes a difference. As pointed out earlier, the source of authority of a particular officer to act as a disciplinary authority and to dispense with the inquiry is derived from the service rules, while the source of his power to dispense with the disciplinary inquiry is derived from the second proviso to Article 311(2). There cannot be an exercise of power unless such a power exists in law. If such a law, if power does not exist in law, the purported exercise of it would be an exercise of a non-existent power and would be void. The exercise of a power is therefore always referable to the source of such power and must be considered in conjunction with it, being in my case the service rules not. The court's attention in Chalapan case was not drawn to this settled position of law, and hence the error committed by it in considering Rule 14 of the Railway Servants Rule by itself and without taking into account the second proviso of Article 311(2). It is also well settled that where a source of power exists, the exercise of such power is referable only to the source and not to some other source under which, were the power exercised, the exercise of such power would be invalid and without jurisdiction. Similarly, this is on the power logic. So I'm reading further. Similarly, if a source of power exists by reading together 2 provisions, whether statutory or constitutional, and the order refers to only one of them, the validity of the order should be upheld by construing it to be an order passed under both these provisions. Further, even the mentioning of a wrong provision or the omission to mention the provision which contains the source of power will not invalidate an order where the source of such power exists, which is also on the probationary. The omission to mention in the impugned orders the relevant clause of the second proviso or the relevant service rule will not, therefore, have the effect of invalidating the orders, and the orders must be read as having been made under the applicable clause of the second proviso to Article 311(2), read with the relevant service rules. Then para 128, Lordship, next page. The main thrust of arguments as regards clause B of the second proviso of Article 311(2) was that whatever the situation may be, a minimal inquiry or at least an opportunity to show cause against the proposed penalty is always feasible and is required by law. The arguments with respect to the minimal inquiry were founded on the basis of the applicability of Article 14 and the principles of natural justice, and the arguments with respect to an opportunity to show cause against the proposed penalty were in addition founded on the decision in the Chalapan case. These contentions have already been dealt with and negatived by us, and we have further held that the Chalapan case insofar as it held that a government servant should be heard before imposing a penalty upon it was wrongly decided. The next contention was that even if it is not necessary, reasonably practicable to hold an inquiry, a government servant can be placed under suspension until the situation improves and it becomes possible to hold the inquiry. This contention also cannot be accepted. Very often, a situation which makes it not reasonably practical to hold an inquiry is of the creation of the concerned government servant himself or of himself acting in concert with others or his associates. It can even be that he himself is not a party to bringing about the situation. In all such cases, neither public interest nor public good requires that the salary or subsistence allowance should be continued to be paid out of the public exchequer to the concerned government servant. It should also be borne in mind that in the case of a serious situation which renders the holding of an inquiry not reasonably practicable, it would be difficult to foresee how long the situation will last and when normalcy would return. It is impossible to draw a line as to the period of time for which the suspension should continue, and on the expiry of the period, action should be taken under clause B of the second proviso. Further, the exigencies of a situation may require prompt action should be taken, and suspending the government servant cannot serve the purpose. Sometimes not taking prompt action may result in the trouble spreading and the situation worsening and at times becoming uncontrollable. Not only prompt action, but may also be construed by the troublemakers and agitators as a sign of weakness on the part of the authorities and thus encourage them to step up the tempo of their activities or agitation. It is true that when prompt action is taken in order to prevent this happening, there is an element of deterrent in it, but it is an unavoidable and necessary concomitance of such an action resulting from a situation which is not the creation of the authority. After all, clause B is not meant to be applied in ordinary, normal, but in some situations where it is not reasonably practical to hold. Para 131, next page, Lord. Then I'll shift to the next section. It was submitted that where a delinquent government servant so terrorizes the disciplining authority that neither the officer nor any other officer stationed at that place is willing to hold the inquiry, some senior officer can be sent from outside to hold the inquiry. This submission itself shows that in such a case, the holding of an inquiry is not reasonably practical. It would be illogical to hold that the administrative work carried out by senior officers should be paralyzed because of a delinquent officer, that is public servant, government servant, either by himself or along with or through others, makes the holding of an inquiry not practical. This was the sum and substance of what I wish to touch in this judgment. Next, Lordship, at page 169 is the Kuldeep judgment. Lordship, this is on acquittal not leading to automatic reinstatement. 168. So 1996, 10 SC.
Is it relevant for our purpose? How is it relevant?
Not really, Lord. Okay.
Why do you?
I'm just pointing that out because the argument came up on.
No, there was no argument to this
Not before Lord.
in this regard.
Yes, Lord.
Not at all. And has there been any acquittal? Has there been any acquittal? No. So why this judgment is relevant otherwise?
We'll use it later.
Hmm?
We'll use it later. We'll use it later, Lordship.
Maybe.
Yeah.
Maybe.
Perhaps Lordship. Southern Railways, Lordship. That's at 176, Lordship. 2009, 9 SCC 24. Southern Railways Officers Association versus Union of India.
Yes.
Lordship, basically on page 180, the facts are that the employees were rough with the senior officer.
These are cases of dispensing with inquiry, Mr. Kohli.
Again, these are.
Or you want us to learn the principles? We are happy. We are fine.
Lordship, we learn. We learn. This is not the attempt. So yes, Lordship. I think that's fair. We can go to the next. This is, you're done with this? The next one. Lordship, I have a few judgments in hand which we made copies of.
Sure.
Lordship, give the book citation. So Lordship, there's three which we have given citation, which is Joginder Pal. I'm only just going to show that we have marked it already, but it's my duty to point out Lordship. That was Lordship 2014 6 SCC 644. I'm not even going to read it much, Lordship. I'm just merely going to point out the paragraph.
Yes.
Because Lordship has already seen it. I'm referring to para 12, Lordship. Well, 13, 14, right up to Lordship. 23, Lordship. And I'm deeply obliged, Lordship. I'd already marked para 19 is the critical one, where it will be dealing with the tainted candidate.
Yes.
And as far as the cases are concerned, they hardly pose any challenge, as has been specifically found for the aforesaid reasons, have indulged in unfair means and have been selected either paying fine or because of the other extraneous reason. So this was, of course, tainted, non-tainted, but for the tainted, the court actually brushed it aside and said that this is something which is not a challenge for us. So I just wanted to point out those paras. I'm not reading it, Lordship. I don't think there's a requirement. Then Lordship, Shamsher Singh versus State of Punjab is 1974, 2 SCC 831, 7 judges, Lordship. I will refer Lordship to the internal pages because
yes,
yes, Lordship. Page 851, Lordship.
Yes.
851, Lordship. So one page earlier, Lordship, just I'll point it out, I won't read it. Para 62 refers to Purushottam Lal Dhingra, Lordship. Para 63 said that no abstract proposition can be laid down, but it's para 64 which I'm reading. Before a probation is confirmed, the authority concerned is under an obligation to consider whether the work of the probationer is satisfactory or whether he is suitable for the post. In the absence of any rules governing a probationer in this respect, the authority may come to the conclusion that on account of inadequacy for the job or for any temperamental or other object not involving moral turpitude, and the probationer is unsuitable for the job and hence must be discharged. No punishment is involved. 887, Lordship. Bottom of the page, Lordship.
Yes.
Yes, the learned Chief Justice summarized the legal position. This is, Lordship. The appointment to a post on probation gives the person so appointed no right to the post, and his service may be terminated without taking recourse to the proceedings laid down in the relevant rules for dismissing a public servant or removing him. So this is important, Lordship, without recourse to the rules. 2. The termination of employment of a person holding a post on probation without any inquiry whatsoever cannot be said to deprive him of any right to the post and is therefore no punishment. 3. But if instead of terminating such a person's service without an inquiry, the employer chooses to hold an inquiry into his alleged misconduct or inefficiency, or for some similar reason, the termination of service is by way of punishment because it puts a stigma on his competence and thus affects his future career. In this case, he is entitled to the protection under Article 305. But if the employer simply terminates the services of a probationer without holding an inquiry and without giving him a reasonable chance of showing cause against his removal from service, the probationary civil servant can have no cause of action, even though the real motive behind the removal from service may have been that his employer thought him to be unsuitable for the post he was temporarily holding on account of his misconduct, inefficiency, or some other. It's just what we've been arguing, Lordship. Then, Lordship, Purushottam Lal Dhingra versus Union of India, 1958, AIR 1958, SC 36, by Judge Lordship. Para 25.
Yes.
Lordship may turn to the next page. I'm coming, Lordship. I am reading actually in the middle of the paragraph, Lordship,
Hmm.
where it says, thus under Article 311(1), the punishment of dismissal. It may be on the next page.
Reading para 15,
25, Lordship.
25.
Lordship 25.
Yes.
So it flows thus from under Article 311(1).
Hmm.
The punishments of dismissal or removal cannot be inflicted by an authority subordinate to that by which the servant was appointed. And under Article 311(2), the punishment of dismissal, removal, and reduction in rank cannot be meted out to the government servant without giving him a reasonable opportunity to defend himself. All bona fide entry, Lordship. The principle embodied in Article 310(1), that the government servants hold office during the pleasure of the president or the governor, as the case may be, is qualified by the provisions of Article 311, which give protection to the government servants. Lordship, next. The net result is that it is only in those cases where the government intends to inflict upon three forms of punishment that the action proposed to be taken in regard to him. It follows, therefore, that if the termination of service is sought to be brought about otherwise than by way of punishment, then the government servant whose service is so terminated cannot claim the protection of Article 311(2), and the decision citing before us and refer to the above insofar as they lay down the principle must be rightly decided. Then, Lordship, in the next paragraph, it says, Lordship, there is a point 1, Roman 1 italics, Roman 2 italics, Lordship. And in Roman 2 italics, it starts, thus when the service of a government servant. Has Lordship got that? Right at the bottom of para 26. It will be almost about 20 lines below, Lordship.
Yes.
Thus, when the service, thank you, Lord. Thus, when the service of a government servant holding a post temporarily ripens into a quasi-permanent service as defined in the 1949 temporary service rules, he acquires a right to the post, although his appointment was initially temporary, and therefore the termination of his employment, otherwise than in accordance with Rule 6 of those rules, will deprive him of his punishment to that post, which he acquired under the rules, and will prima facie be a punishment and regarded as a dismissal or removal from service so as to attract the application of Article 311. Except in the three cases just mentioned, a government servant has no right to his post, and the termination of service of a government servant does not, except in these cases, amount to a permanent post in a government service on probation. The termination of his service during or at the end of the period of probation will not ordinarily and by itself be a punishment for the government servant so appointed has no right to continue to hold such post any more than the servant employed on probation by a private employer is entitled to do so. So they are making that comparison of a private employer with a probationer in the government. Such a termination does not operate as a forfeiture of any right of the servant to hold the post, for he has no such right and obviously cannot be a dismissal, removal, or reduction in rank by way of punishment. Further, Lordship, in this paragraph, about 10 sentences below, it says shortly put. Just two more.
Yes, yes.
Yeah. Shortly put. The principle is that when a servant has the right to a post or to a rank, either under the terms of contract of employment expressly or implied or under the rules governing the conditions of his service, the termination of the service of such servant or his reduction to a lower post is by itself and prima facie a punishment, for it operates as a forfeiture of his right to hold the post or the rank and to get the emoluments and other benefits attached thereto. But if the servant has no right to the post, as where he is appointed to a post permanent or temporary, either on probation or on an officiating basis, and whose temporary service has not ripened into a quasi-permanent service as defined in the temporary service rules, the termination of his employment does not deprive him of any right and cannot therefore by itself be a punishment. One test for determining whether the termination of the service of a government servant is by way of punishment is to ascertain whether the servant, but for such termination, had the right to hold the post. If he had a right to the post, as in the three cases herein above mentioned, the termination of his right will by itself be a punishment and he will be entitled to the protection of Article 311. In other words, and broadly speaking, Article 311(2) will apply to those cases where the government servant, had he been employed by a private employer, will be entitled to maintain an action for wrongful dismissal, removal, or reduction in rank. To put it in another way, if the government has by contract, express or implied or under the rules, the right to terminate the employment at any time, then such termination in the manner provided by the contract or the rules prima facie and per se is not a punishment and does not attract the provisions of 311. Para 28. The position may therefore be summed up as follows. Any and every termination of service is not a dismissal, removal, or reduction of rank. A termination of service brought about by the exercise of a contractual right is not per se dismissal or removal, as has been held in Satish Chandra Anand versus Union of India. 4 sentences below, Lordship. It is true that the misconduct, negligence, inefficiency, or other disqualification may be the motive or the inducing factor which influences the government to take the action under the terms of the contract of employment or the specific service rule. Nevertheless, if a right exists under the contract or the rules to terminate the service, the motive operating in the mind of the government is, as Chief Justice Chagla said, wholly irrelevant. In short, if the termination of service is founded on the right flowing from the contract or the service rule, then prima facie, the termination is not a punishment and it carries with it no evil consequences. And so Article 311 is not. Okay. This is 2021 Lordship, 12 SCC, 569, State of Rajasthan versus Hemsi. Although Lordship, it is on acquittal also.
It's on acquittal.
And Lordship, I may I'm holding an earlier copy which is online, so I'm one paragraph apart. So my paragraph 2 is there. It might be one in Lordship's thing. This appeal is from a judgment dated 24th April.
Yes.
Yes, Lordship. So I'm one paragraph.
Yes.
Of a division bench of the High Court of Judicature of Rajasthan at Jodhpur, the respondent, who was a police constable, filed a petition under Article 226 of the Constitution to challenge his dismissal from service after a disciplinary inquiry. A single judge of the High Court, by judgment dated 18, dismissed the petition. The division bench reversed the judgment and concluded that there is no evidence in the disciplinary inquiry to sustain the finding that the respondent committed a murder while on leave from duty. Independently, he was also acquitted in the Sessions trial on the charge of murder. The division bench granted the respondent reinstatement in service with no back wages for the 17 years that had elapsed since his termination. So it comes in appeal. Para 5, Lordship. Merely records that the acquittal took place by the additional.
This is not at all relevant.
Yes,
this is
it's on acquittal.
Not at all. It's on acquittal basically.
Yes.
Yes.
Then Lordship, Khatri has been Khatri. The case of
Khatri.
Lordship Khatri versus State of Bihar, 1981, 2 SCC. 1981, 2 SCC 093.
Yes.
We'll wait for the book to come to Lordship. Because Khatri was argued in 1981, 2 SCC 093. ये तो देखो, Rita Mishra, do you have copies? We don't. This one.
You can, your associates can give the list in advance. If you don't, you're not provided the copies,
Yes, Lordship, I met.
then the list should be given.
That's why I said I regret that. In fact, it was done. I was busy reading. It should have struck me also. So we can shift to the other.
No, it's okay.
No,
Oh,
it's only one paragraph.
the compilation of Mr. Mishra, maybe it's there. Khatri has not been
No,
given.
Lordship, this was argued actually by Ken Chaudhary.
Mr. Ken Chaudhary, yes. Yes.
Okay.
Hmm.
I'm on page Lordship 501. One paragraph. And this is Lordship, the paragraph 5, after quoting Queen Empress versus Manu. Next paragraph starts the criminal court holding an.
Yes.
Yes, Lordship. The criminal code holding an inquiry or trial of a case is therefore empowered by subsection 2 of section 172 to send for the police diary of the case, and the criminal code can use such diary not as evidence in the case, but to aid it in such inquiry or trial. But by reason of subsection 3 of section 172, merely because the case diary is referred to by the criminal code, neither the accused nor his agents are entitled to call for such diary, nor are they entitled to see it. If, however, the case diary is used by the police officer who has made it to refresh his memory, or if the criminal court uses it for the purpose of contradicting such police officer in the inquiry or trial, the provisions of section 161 or section 145, as the case may be, of the Indian Evidence Act would apply, and the accused would be entitled to see the particular entry in the case diary, which has been referred to for either of these purposes, and so much of the diary as in the opinion of the court is necessary for a full understanding of the particular entry.
You can come to the bottom 6 lines.
Yes, Dr. Vai, that is the most important point.
Yes.
I'm just reading the next 4 sentences, and I'm grateful. That is my case on this. It will thus be seen that the bar against production and use of case diary enacted in section 172 is intended to operate only in an inquiry or trial for an offense, and even this bar is for a limited bar. Because in an inquiry or trial, the bar does not operate if the case diary is used by the police officer for refreshing his memory, or the criminal code uses it for the purpose of contradicting. And next, Lordship, this bar can obviously have no application where a case diary is sought to be produced and used in evidence in a civil proceeding or in a proceeding under Article 32 or 226 of the Constitution, and particularly when the party calling for the case diary is neither an accused. No, that was the only thing. To distinguish it. It can be used, that was the argument.
It can be used, but that bar against use, then the copy has to be provided. So this argument also doesn't help you much.
One is R. Vishwanath Pillai versus State of Kerala. We have given a copy just now, Lordship. This is 2004 to SCC 105, 3 judge, Lordship. This is the case, Lordship, of dismissal after 27. Lordship may come to para 4. I'll just read the factual matrix.
Yes.
In the school record, the caste of R. Vishwanath Pillai, wherein after referred to as the appellant, was recorded as Veduvar Pillai. His father was one Radhakrishna Pillai. He was a Nair by caste. His mother's caste was Veduvar Pillai, Nair, as well as Veduvar Pillai, a forward caste. The caste of his brother and other 2 sisters in the school record was also recorded as belonging to forward caste. The appellant obtained a community certificate in 1969 from the Tehsildar, stating that he was a member of the Vettuvan community. On the basis of this certificate, in the year, he was able to get an appointment as assistant in the Legislative Secretariat in the year 1973 against a post reserved for the SC. In the year 77, he was selected as direct recruit to the post of DSP, Deputy Superintendent of Police, against a seat reserved for the scheduled caste on the basis of caste certificate obtained by him. He was subsequently promoted and included in the cadre of APSC. The government of Kerala, on inquiry into the caste status of the appellant, on the basis of a complaint received, ordered a full-fledged anthropological inquiry into the caste status of the appellant. It was alleged that the appellant did not belong to the scheduled caste and had usurped the post meant for a scheduled caste. This was the factual matrix, Watch.
There are 7.
Yes, Watch.
There are 7. That is a case wherein the issue regarding caste was decided in an earlier proceeding against the employee. So his entry into service was non-est rather. Absolutely.
Lordship, that's the point. For 27 years, if the entry is non-est and it's not bona fide,
that's what we told you, Mr. Kohli, right from the beginning. If you can satisfy us that the material on which you declared that their entry is non-est, the situation will be different.
Lordship, we should see that material. We will place it for Lordship.
Not only see, first we clearly feel that you are avoiding that issue. That all right, first address on that issue. Why the material regarding 9 candidates similarly placed as the appellants herein was concealed by Ayub.
Then Lordship may permit me to specifically address that tomorrow morning.
Yes, definitely.
One judgment, last judgment, Lordship.
Sure.
This Lordship we have given, it's actually a full bench of Patna High Court. It's called Rita Mishra versus the Director of Primary Education. This is full bench. There was a dissenting, but Lordship is 1987 SCC online Patna 159. It's approved in State of Bihar versus Devendra Sharma 2020 SCC. This is, I will read a little in detail.
Yes, please.
Whether a public servant is entitled to a writ of mandamus for the payment of salary to him for the work done, despite the fact that his letter of appointment was forged, fraudulent, or an illegal one, is the significant question in this set of 13 connected writ petitions, referred to for an authoritative discussion of the full bench. So, Lordship, basically, they were teachers who had got forged letters in the hand. The officer who was giving the letters gave them forged and fabricated. They went and discharged that job as a teacher. And then when they were removed, they claimed that at least for the period, we should be getting it. This is the factual matrix, Lordship. Then, Lordship, para 4 deals with the counter affidavit, Lordship of the state. Basically saying that it is invalid, Lordship, and their appointment is non-est.
So the fact regarding the appointment being non-est was not in dispute. They only claimed salary for the period they had worked. For that, you cited an earlier judgment, wherein the Supreme Court saved the salary.
Lordship also, what Lordships have dealt with is, Lordship is, they have dealt also with, in terms of the writ of the mandamus and all, they've quoted that. So that's why I was relying.
Carry on, carry on. Read as per your convenience.
The Lordship from para 11.
Yes. Para 11.
Taking up the first category of appointment letters which are established to be forged, it is perhaps appear that this is further divisible into 2 subcategories, namely if the appointee is directly a party or privy to the forgery. Now, Lordship, why I'm reading these is because there's an element here that figures with my case, that if you are a party and a privy to the appointment itself being non-est and tainted in terms of rewriting the exam, that is why I'm trying to make draw parameteria kind of a situation. To the forgery, where in fact he was not so, adverting to the first category, it is clear enough that a forged document is a non-est and a nullity. Then, Lordship, all this deals with that. Then next, Lordship, in para 30.
32.
13, Lordship. I'm just racing through it, Lordship.
Yes.
And Lordship, the last sentence being, the whole paragraph is there, but last sentence being, in particular, if the very appointment is rested on forgery, no statutory right can flow from it. So the first point I made, Lordship, is that they are a party to it. Then no statutory right can flow from it. Then para 15, Lordship. To sum up this aspect, it seems somewhat plain that where the letter of appointment is a forgery and the appointee is a party, that Lordship should be party, not party, and privy to the same, no substantive right to salary would arise. However, long the person may have fraudulently worked in the post in actuality. To my mind, no legal right can stem from a crime herein because of the original factum of forgery. So no legal right if there is a crime at the inception. Such a person is not an employee at all and far from being a public servant in the eyes of law, even on the basis of a forgery. Then, Lordship, para 16 is the second category, Lordship. Those who are not party. As regards the subcategory where the appointment letter is established to be forged, but the appointee is not a party or privy to the same, the position would be only a step down on the same ladder. What has been said above would be mutatis mutandis applied to this situation as well. As observed earlier, the very appointment letter being forged is a non-est and null. Then Lordship may turn the page. Above para 17, the 5 lines. On the next page, page 33. The onerous burden of proof.
Yes.
The onerous burden of proof in this situation would lie entirely upon the claimant. Plainly enough, these are tangled and contentious issues of fact, which can, if at all, be determined in a well-contested and well-fought-out suit in the civil forum only. These are matters far removed, remote and far removed from an adjudication in the extraordinary writ jurisdiction. Lordship, para 17A. It is unnecessary to multiply authority, and there is no dearth thereof that fraud would thus vitiate even bilateral rights arising from a contract. Once it is so held, rights springing from law and status and the high pedestal of public employment having a statutory base deserve even greater protection and sanctity. Consequently, it must be held in no uncertain terms that where the source of the right is rooted in fraud or established dubious considerations, no right stricto sensu for salary could arise and far less be enforceable by way of a mandamus in the writ jurisdiction. Para 18, Lordship. Adverting now to the last category, where the letter of appointment is illegal, being flagrantly violative of the statutory procedure prescribed for selection and appointment. Again, the position does not appear to be materially different. It bears repetition and reiteration that the statutory right to salary in public service stems from the legal right to hold the post. If it is once held that the very threshold stage of appointment is illegal, then in the eyes of law, no appointment to the post into this public service. The door stands barred and slammed in the face of such an intruder. It was contended forcefully that where the procedural requirements of selection and appointment are statutory and have not been complied with at all, there is no appointment in the eyes of law. Consequently, no right to salary stricto sensu can arise before the very threshold stage is tainted with illegality. In Lordship, para 19. He refers to the earlier judgment and says, Lordship says, I read the aforesaid enunciation and the ratio of the said judgment as conclusive on the point that an appointment flagrantly contrary to statutory requirements is non-est and cannot be validated on any theory of factum value. Then Lordship, para 23. He's taking the argument of the learned Advocate General. Before parting with this aspect, one must notice the somewhat fair stand of the learned Advocate General that the legal position might well be different when there is only a minor irregularity in the letter of appointment and the same is not void ab initio. An example which was given to us was where the initial entry into the service is valid, but further continuation may not be in absolute conformity with law. Now, Lordship, this is not that case. In such a situation, perhaps the person having bona fide and diligently worked on a post may be entitled to be compensated. And then it goes on to expand on that. Para 25A, Lordship. The primary scope and function of the writ of mandamus has been pithily expressed in the phrase that this writ is issued to command and execute and not to inquire and adjudicate. It is not to establish a legal right, but to enforce one. It is only when the legal public duty is clear, unqualified, and specific that a writ of mandamus can be truly claimed. It is not to be granted where the claim of the petitioner has in fact to be first established, adjudicated upon before it can be enforced. As in the present case, a frontal challenge is laid to the petitioner's claim on every aspect and the averments on their behalf are sought to be controverted at every step. It is manifest that the petitioner's claim has to be gone into, adjudicated, then established. This obviously is not the scope of the writ of mandamus. Whereas the law on extraordinary legal remedies has said, the office of mandamus is to execute, not adjudicate. It does not ascertain or adjust mutual claims or rights between parties. If the right be doubtful, it must first establish as well as enforce a claim of uncertain merit. It follows, therefore, that mandamus will not be granted where the right is doubtful. Then Lordship, it quotes again Halsbury's. And then para 30.
Talks of disputed questions of facts.
Yes, Lordship. Now, para 26. It is evident from the authoritative exposition of the law that the sine qua non for the issuance of a writ of mandamus is the existence of a statutory or a public duty devolving upon the person or the body against whom or which the said writ is directed. Equally settled it is that along with this must coexist a corresponding right in the petitioners who were entitled to claim the enforcement of the said statutory public duty. Unless these two preconditions are satisfied, the requisite foundation for the issuance of a writ of mandamus can hardly be said to exist. Applying the twin test in the present context, I am of the view that neither one stands satisfied. Then Lordship, in para 27, he expands further on it. Then Lordship may come to para 28. There is yet another impassable hurdle in the way of the petitioners in this context, as stands already noticed. Every conceivable material fact averred on their behalf has been categorically contradicted and challenged in the pleadings and even more forcefully assailed at the bar. It needs no great erudition to see that the writ jurisdiction is clearly confined to facts alleged and admitted on affidavits or those not seriously traversed on the record. As it is well known, it is the extraordinary remedy resorted to when the basic factual position is not in dispute. It is to be borne in mind that the writ jurisdiction is not and cannot be made a substitute for a regular trial, by way of a suit for determination of contentious matters for which the parties are diametrically opposed on material facts. This indeed is a reason for declining to exercise the discretionary writ jurisdiction in cases where intricate and disputed the questions of facts are raised, unless, of course, as a very exceptional measure, the writ court itself proceeds to record evidence and then arrives at a finding thereon. Apart from the fact that this is rare and is indeed resorted to for very special reasons, it is elementary that the court would then allow the parties the right of leading evidence, production and cross-examination of witnesses and the rebuttal thereof in order to arrive at a considered finding of facts. Then Lordship continuing, this is the position generically in the writ jurisdiction, and in my view, it would be doubly so when a writ of mandamus is sought to be claimed. As was noticed earlier, mandamus issues only to enforce an unqualified established right and not where the petitioner's claim has to be first adjudicated. Para 39, Lordship, deals with coming to the court with clean hands, Lordship. 29. And Lordship, para 30. Now, once it is so that even a calculated and designated design suppression of material fact in the writ jurisdiction would non-suit the petitioner, then it seems that more so that when the stand of the respondent state is that the claim is based on a punishable crime like fraud or forgery, the list cannot be gone into in the writ jurisdiction. Para 44, Lordship.
Yes.
It now remains to advert to the judgments of this court, all passed in the motion state itself directing the payment of salary, which is why it came to the full court. Para 46, Lordship, the conclusion. In this somewhat exhaustive judgment, it is indeed apt, if not necessary, to collate the basic conclusions arrived at. In the light of the aforesaid discussion, it is subsequently held, where the letter of appointment is a forged one and the appointee is either a party or a privy thereto, then no substantive right to salary can accrue. Paramateria, if you are party in terms of the appointment itself being fraudulent, you can't claim that benefit. Whether letter of appointment is forged, but the appointee is neither a party nor a privy to the same, even then no substantive right or to the statutory salary can arise from a document which is non-est or a nullity. It is neither necessary nor desirable to pronounce on the aspect whether a civil suit for compensation under Section 70 Contract Act, etc. 3. Whether letter of appointment has been obtained by the appointee fraudulently or for dubious considerations, no substantive right to salary stricto sensu would arise. Whether letter of appointment is flagrantly violative of the prescribed statutory procedure for selection and appointment to the post, the same would be illegal and there would be no valid appointment in the eyes of law, no substantive right to salary. 5, Lordship. On the procedural aspect, where the basic and material facts are categorically controverted and traversed, the exercise of writ jurisdiction would be inapt, and this would be doubly so in the case of a writ of mandamus, which cannot possibly issue on a slippery base. Para 46 only Lordship holds that the appointment is illegal, no benefit. And finally, para 49, which is on the principles of natural justice. A somewhat curious and a last-ditch attempt was then made on behalf of the petitioners to invoke the principles of natural justice. It was sought to be contended that the burden, instead of being on the petitioners, should be entirely shifted to the shoulders of the respondent state. It was argued that it was incumbent that the state should have first held a full dress inquiry and after affording a reasonable opportunity to the petitioners should have established that the purported letters of appointment, which are admittedly in the petitioner's possession and within their knowledge, are forged and fraudulent and illegal, and only thereafter the petitioner's salary should have been denied. This stand has not only to be noticed, this stand has only to be noticed to be rejected. Undoubtedly, the burden must lie on the petitioners, and it is they who have to establish their claim on the basis of a valid appointment and not for the respondent state to prove the negative. The claim of full dress inquiry after associating the petitioners in a writ of mandamus is plainly ill-founded and does not lie in the mouth of the petitioners on principles and even on the basis of precedent on which reliance has been placed by the petitioners too. It is wholly settled that where the very original appointment to the service is invalid or forged or fraudulent, then in the eyes of law, there is no appointment at all. And the declaration by the state that the alleged appointment is non-est does not attract any principle of natural justice. Para 51, Lordship. It would be manifest from the authoritative findings of the full bench and division bench that even in the cases of termination of services, The rules of natural justice are not retracted when the original appointment itself is void ab initio. Now, once that is so, a fortiori or a question of any rules of natural justice arises merely in the case of refusal of salary in an identical context. In light of the aforesaid exhausted discussions, both on the matter of law and merits, the writs must fail. No mandamus for the payment of salary can possibly issue. The petitioners, if so advised, are relegated to the ordinary remedies by way of a suit. We would say, of course, in the criminal trial. Lordship, that is the sum and substance of all the judgments. I have to respond to Lordship specifically on those 9. And I will also respond on the 3 probationary, the 3
Approvals.
and detail.
Well, their argument, Mr. Kohli, was that if you say that they were not confirmed in service, you're resorting to the rules for discharging them on the ground that the probationers have no right to be heard. You have not exercised the powers under the rules because there is no discussion or no consideration of their suitability for the period served, which gives you a right under the rules to discharge them. If during the service tenure, there is not even a whisper that their performance was substandard, subpar, then whether you can take recourse of the rules to say that we have a right to discharge them. That is their argument, which still has to be addressed. Arguments were advanced by Mr. Kohli, Senior Counsel, assisted by so-and-so, representing the respondent's state and others. The arguments hearing remained inconclusive. Yes.
9%, your lordship has addressed to my learner 9. It's a 9 tabulation states, 9 pages, which consist of more than 42.
42?
Yes, we have given that list.
Okay. You have provided a copy?
Yeah, we have. Yeah, I have given a copy.
Okay.
Yeah.
9 pages is the list.
9
and the candidates are 42.
42. More than 42 also.
Okay. Let's see. And the original record, presumably, Mr. Kohli, you are carrying the original record?
I will need to Lordship take that from him because what I got on the email was very unclear.
No. Are you carrying the original record of this
Not today.
process? You'll have to keep it ready tomorrow.
No, this is forming a part of additional affidavit which was filed in the month of April. Yes.
I'll take the details.
Yeah, you
Just after.
Give a fresh copy
I'll give
so
it.
that he can
Yes.
respond to it easily. And hearing remained inconclusive. List tomorrow for further hearing. What happened?
He was asking me, Lordship, how much time I'll take. I said, it depends on Lordship on the material. I said, जाने के बाद ही बता पाऊंगा Lordship. That's what I said.
Possible there.
This Lordship is a very good exercise on live streaming because we could see the arguments back again and hear them again. So it's really a wonderful thing. Not all courts are following it. But
I don't know. We have been doing it right from the day I landed here. I've been trying to follow that.
very, very good and very useful.
Passed over meter, item 52 to 54.
Mr. Das, Mr. Kohli has summed up his arguments very quickly. He deserves a good cup of coffee, if not anything else.
Yes.
Yes. Which are these matters? Yes.
Item number 52 and 55 I am appearing, my lord.
Yes.
Sir, item 52, my lord, is the service is not complete, I think.
Service is complete.
52.
I think everyone, 52, please give. What is the status of the selection? The proceedings were stayed, this selection was stayed. What about APSC? Who is representing APSC in this case? (52, 53).
Since appointment of election was decided, that post is still not.
only one post or the entire one post?
My lord, advertisement are issued for filling up
Four.
number of post of deputy director, my lord.
So for one post wherein the reservation was provided to ST,
STP.
you had
No, my
a
lord.
grievance.
I was not a party in the writ petition, my lord. We were appointed against the unreserved vacancies, my lord, two posts, and we are from ballistic department, my lord. Our requirement is MSc in physics, and their claim is in serology department, where the educational qualification is MSc in biology. So their claim is that post reserved for STP has to be reserved for OBC. We were appointed against unreserved vacancies, my lord.
So they challenged your appointment.
No, my lord.
Then
Their claim was that that post reserved for STP should have been reserved for OBC.
OBC because it was not as per the roster point.
Yes, my lord.
Okay.
There was no challenge to my appointment, my lord.
Still that was interfered.
Yes, my lord. The entire advertisement was set aside, my lord.
Advertisement was set
In
aside.
fact, my lord, they are not eligible for holding that post because they are not the MSc in physics, my lord. For
Okay.
ballistic MSc in
Okay.
physics is the requirement,
Okay.
which I am we are holding, my lord.
Who's there for the APSC? No one. Anyhow, let's see the file, item number 52. He's saying that service is not complete.
Lordship, I am applying for respondent. Since only respondent one is answered, my lord. Subsequently, I.
Just hold on. In 52, you are appearing. For respond number
One
1
and
and 2.
that.
So number 6 is Director FSL. Mr. Nath will be appearing. So let and council. What about 3 and 4? What about 3?
I can know, I am for
3. So learn council. Your good name, please.
M. Mohan.
M.
Mohanta.
Mohanta appears for the response numbers 1 and 2. Your good name, please. NJ Gogoi for the response number 3. Mr. D. Nath appears for the response numbers 4, 5, 6, and 9. Right? 9 also. No one appears for the APSC. Response number 7 and 8. Despite service. Thus, notices have been served. List for admission after 3 weeks.
Deeply obliged.
What in 53 also?
53
Service is
I am appearing, my lord. I am for appealing.
already appearing. So same order sheet in all the cases. You are appearing. Where were you? For APSC Learned Council. So and so forth. List for admission.
My lord.
Respondents check कर लेना होना चाहिए ना. वैसे इसकी लिख दीजिए ना. Mr. Nath appears for the state respondents and Mr. So and so appears for the APSC.
Item number 58.
Yes.
My lord, they have filed an affidavit, my lord. I just pray for 2 days time to file a reply, my lord, because I find some inconsistency in these certificates.
Okay.
The matter will be called on Friday or Monday, my lord.
Affidavit on behalf of the respond number
I'm the
2 to 5. Who has filed the
Yes.
affidavit? Has been filed by
2 to 5. 2 to
2 to has been filed. Then council, senior council, Mr. Chaudhary, representing the appellant, prays for short opportunity to file an affidavit in reply, if so required.
Yes. No, it will be required.
You will
but
be.
That's why I'm praying for that.
List on
Either Friday or Monday, my lord.
3rd
Oh,
October.
Monday is a holiday.
Monday, 3rd October.
Yes. Affidavit में file करूँगा, my lord. Inconsistency.
Item number 64.
Yes.
Separately, my lord, we have given that certificate.
You pass on a copy to Mr. Chaudhary. They have also
given, they have annexed the copy, my lord.
No, in the affidavit that has not been.
They have not in the affidavit.
Oh.
इसमें लिखिएगा. Mr.
There you have.
Shri Tiwari has also placed on record
Not voucher, also the
certain certificates,
separately.
the
given that-
Provident Fund EP certificates issued, copies of the certificate issued to the to Messrs. Brahmaputra Infrastructure Limited by the EPFO. Copies thereof have also been provided
Similar
to
period.
Mr. Chaudhary.
Yeah. Okay.
Mr. Tiwari, why don't you file it with a formal application? It's better.
Sorry.
Since we are
Mr.
getting
Tiwari
some
submits
time.
that he would be placing on record copies of the certificates issued to Brahmaputra Infrastructure Limited by the EPFO. in the year 2015. Okay. Which, as per Mr. Tiwari, are available online.
Yes.
Okay.
No system generated.
And the copies are system generated. Sure. Yep. Return the copies back. Yes. 64. Yes.
Lordship, we have filed an additional affidavit, my lord. Perhaps it's not.
Then counsel for the appellant has filed an additional affidavit. The same be brought on record, list after 1 week. Agya? List after 1 week. Anything else? Okay.
Item number 49.
Hmm?
Item number 48.
48.
There is a challenge to the validity of an act.
Hmm.
And I would like to just file an affidavit.
There was on last date, you made a mention that you will like to bring something on record.
No matter, I think what they have done, I don't know, substantial has come up. So I'll go on merit front. They are really, they are not.
Last date, your statement is recorded that some more time is required to place on record decision of the government.
Committee was formed, the committee possibly ultimately gave an opinion that another committee is formed. I cannot take time on this ground.
Very well.
I'll argue on merit front. Which will give us some time to file an affidavit.
As jointly prayed, you want to file an affidavit now.
That means they will be contesting on merit.
Yes, ma'am.
Submits that, Mr. Mazumdar submits that he has been instructed to argue the matter on merits, and thus would need some time to file an affidavit in opposition on behalf of the state. Since the writ petition is pending from the year 2016, in the interest of justice, one opportunity of 4 weeks is granted to Mr. Mazumdar in the changed circumstances for filing the affidavit in opposition, list in 4th week of November.
14th.
4th week of November.
Deeply.